Ingrown hairs don't just affect you, my bro. They also affect the ones who mean the world to you. And razor burns? The one who just wants an extra cuddle. So, we made this for you. Gillette Fusion 5 Pro. 5 ultra-sharp blades and the movable head that glides over every contour for our closest, most comfortable shave. Because with less irritation and razor burns, you will feel at your best. And they will feel it too. Gillette Fusion 5 Pro. A shave that's worth it.
Remote access, help desk and ticketing, smart automations, patching, remote access, help desk and ticketing.
And the amazing thing is that it does all this while still being easy to use. And the amazing thing is that it does all this while still being easy to use.
fit me, Matt and Paulus, made to fit you.
Maybe it's Maybelline.
The proliferation of remote workers, the digital nomads, who have the ability to work from anywhere. The influence of these nomads on all of us is far-reaching. They look so cool with captions like "My office for the day," with the ocean and mandatory palm tree for a view. They've spotlighted the value of freedom, autonomy, and flexibility. And I want to say those three again: freedom, autonomy, and flexibility.
Oily skin and imperfections? Effaclar Foaming Gel. And for severe imperfections and marks, Effaclar Micro Peeling Gel.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want it. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
One, two, one. 1, 2, 1, 1. One, two, 1, 2, 1, 2, 1, 2, 1, 2, 1.
Your email is your first online impression. Make it count. With GoDaddy Email, you get a professional address that matches your domain. It builds trust, boosts credibility, and helps grow your brand. Setup is quick, and your inbox is protected with built-in security. And if you ever need help, we're just a call away. Start building your brand, one email at a time.
Mic check 1 2 1 2. Mic check 1 2 1. Sound right 2 on your side. Sound right on your side.
keep looking at the why. Why is this trending? What informs the trend? And keep questioning its value.
Right, good morning, everyone. We are. All right. Good morning, everyone. We are about to start. 1 second.
Good morning, Mr. Justin, Ms. Poe. I was expecting to see Mr. Ngwato here.
We're also expecting to see him. We just established.
Strange then, because if he wants to move an application for a postponement, he should be doing it here. So nobody knows his whereabouts.
Well, we established asking
I would have,
Mr. Miles not to call you in.
I would have expected where the witness is, but rather to be here anyway.
Can I suggest that we and find out how long it will take to get him here?
Thank you. That's okay, and we'll hear from you then.
Tingling and numbness could be signs of vitamin B deficiency. Neurobian helps treat vitamin B deficiency to relieve these symptoms at the root. Ask your pharmacist about Neurobian.
Gold in all its forms tells a story, forgotten, lost, or simply waiting. We don't see gold as a commodity. We see what it means, a piece of the past, a promise kept. With no middlemen, no lowballing, we value your gold for what it truly is. From the moment we arrive, the process is simple, transparent, just like the gold we work with. No games, no tricks, only the fair value of what you're holding in your hand. Cash in hand when you need it most at a price that matches the market, not a cent less. Servicing South Africa, we come to you. Because your gold should always be in safe hands. Gold buyer. Fair, honest, no games, just gold.
I have communicated the fact that we are at the High Court so that we can have the necessary documentation being stamped and accepted by the High Court. And for that, with traffic and accreditation just to come in, that delayed us with that 8 minutes. I profusely apologize. That is not in any way manner to disrespect the Commission.
You said something about communicating. What did you say? I think you said communicated. Or did I mishear?
Sorry, Commissioner, I didn't get that clear.
I thought somewhere in what you were saying, you said something about having communicated. Did I mishear?
Yes. Since at about 7 o'clock this morning, I've been in communication with the attorneys of the Commission, also in terms of exchange of documentation, where they were not having received necessary documentation.
Did that have anything to do with the possibility of you being late?
Yes, my colleague did communicate. He's just outside, but I will give you that. I can be able to give the details in terms of who exactly should communicate.
Kellogg's Cocoa Pops? Mom, please.
First, the power breakfast.
Okay, deal. Cocoa Pops?
Yes, this is the power breakfast.
Want vitamins, fiber, and energy? Kellogg's Cocoa Pops.
Tingling and numbness could be signs of vitamin B deficiency. Neurobian helps treat vitamin B deficiency to relieve these symptoms at the root. Ask your pharmacist about Neurobian.
Communicate that we're running slightly late, or we might.
But in any event, Mr. Ngwato, you knew that you had to be here at 9:30. I do not understand why you would have had to go to the High Court personally. Surely you have other people in your law firm who could do that. And that's a very simple, attending to court and making sure that the matter is properly registered, assigned a case number and all that. That's a very minor, yes important, but very minor administrative issue, which could be done by anybody. It could even be done by administrative people who are not legally trained. Why it should take the owner of the firm, I assume you are the owner of your law firm, to go there and attend to this, it just does not make sense at all to me. For you to then make us wait for you, for something that could be done by someone else. For example, last week, you were there with please remind me, Mr. Malika. You were there with Mr. Malika. Why could Mr. Malika not attend to that? Or whoever else for that matter. This is totally unacceptable, totally unacceptable. It's actually unprofessional conduct to make us wait. Why did you not communicate with Mr. Shaskalsen?
Mr. Commissioner, like I indicated, that I've been in contact with the attorneys.
Why did you not communicate with Mr. Shaskalsen?
I don't have Mr. Shaskalsen's direct number.
You were communicating with the Commission's attorneys. You could easily have gotten his number from them. That's not an excuse.
Commissioner, maybe if I'm given a chance to respond, then the Commission will appreciate.
Yes, go ahead, please. Go ahead.
Thank you. As of yesterday, Commissioner, I have 6 times called DM attorneys, and I spoke to Mr. Mbao to give me the number of Geraldine Berger, who I know and have been introduced since the beginning of this proceedings to be the person, to be the contact person. For the entire day, I was not given those numbers. This morning, I spoke to the main director of DM attorneys himself, and I indicated my disappointment that their law firm, since yesterday, I've been communicating with one of the officials just to get through to Geraldine Berger, and I could not get those details. I was quite very happy when I now deal with the main director, and we started exchanging since this morning. We're traveling with one car. When we were just about to arrive, and there was requested to have a copy of the High Court, I indicated to Mr. Mokhasho that for some reason since this morning, my phone cannot open PDF documents. So I'm waiting for Mr. Malika to come outside court. I'm standing outside court so that I can send the necessary documentation to him. Unfortunately, in this particular instance, there was never any malice or any intention on our side to disrespect the Commission. I've been up since 6 o'clock this morning dealing with this particular matter. We left our office 2 o'clock this morning.
Mr. Ngwato, I will say this, and I do not want us to engage any further on it. what you say from where I'm sitting are excuses that are totally unacceptable. I maintain what I said earlier, which is that knowing that you had to be here at 9:30, there was no reason for you to attend to a minor, yes, important administrative issue that could have been attended to by anybody. Totally unacceptable. The discussion is closed.
Well, we appreciate the apologies for that, Commissioner.
Sorry?
We apologize for that.
Thank you.
Thank you.
Yes, Mr. Chaskalson?
Chair, Mr. Ngwato was going to move a postponement application.
Yes. Mr. Ngwato, we have before us your postponement application. Can you proceed to move it, please?
Indeed. Commissioner, I must appreciate and thank the Commission for having granted us the postponement last week. And indeed, we definitely used off the time to the best of our ability as was granted since last week. However, since we started finalizing the documentation, certain things really cropped up and showed and changed the direction that we were taking, which therefore since necessitated this application. As it's commonly known, we are the creatures of instruction. It's our client instruction then to bring an urgent application in the Higher Court, purely and solely for two reasons. As the Commission is in possession of the papers, I take that the papers might have been read and apologize that they've been submitted to the Commission almost on the 11th hour. The first reason, Commission, is the same reason, one of the reasons that we mentioned last week, that the applicant, before he could even make his first written submission to the Commission on the 17th of December, an interim report was already been issued, which we fully understand and correctly so in terms of section 10.4 of the terms of reference, that the Commission is entitled to do so. But 2 days before he could even make his first written submission, an interim report has already been issued, which had recommendations and findings and recommendations against him. Unbeknown, and obviously we do not have access to that particular interim report, but just a day before our appearance on the 30th of January, which is last week, Friday, the state president publicly announced that he accepted the same report, and therefore an announcement was made that he needs to be charged. It is on the basis, that's the first reason, it's on the basis of that is of the view that even though at the Commission he is a witness, not an accused, but whatever he may be able to say as a witness at the Commission he may incriminate himself, which will be a violation in terms of section 35(3) of the Constitution. The second aspect that made us to then make the application to the High Court, Commissioner, is that in perusing the WhatsApp charts, the nature of the WhatsApp charts and the manner in which they've been extrapolated, it only shows outgoing and incoming. Even messages that were not originated by him, but he received them when they were forwarded to him, appears to be that he's the originator of the messages, which now distort the narrative and the version and how things are in terms of those messages. And as a result, that will then necessitate that he now gains access. Oh, I apologize. That will now necessitate that we look into how the messages were extrapolated in terms of, from his phone, in terms of from the time it was
feel free to either put it on silent or switch it off. Don't feel any pressure not to do that.
Mr. Commissioner, it's not even my phone, it's Mr. Maleka's phone, and I don't know his password or his pattern, how to close it off.
No, that's...
So mine is here, and this is Mr. Maleka's phone. Is Mr. Maleka's phone ringing?
All right, thank you.
So in the manner in which how this, the chain of evidence, or the chain from the time his phone was taken.
Is that Mr. Maleka? Please go across.
Sorry. Sorry. Yeah.
Are you no longer comfortable to support your boss the way you did last week, Mr. Maleka? All right. Please continue. I'm sorry about the interruption, Mr.
Thanks, Commissioner.
Yes.
So the manner in which the charts were downloaded and extrapolated from his phone leaves much to be desired, which appears to be a violation in terms of how the evidence is being presented, because it doesn't show the messages that are forwarded, it doesn't show that he received it as being forwarded to him, but it shows as if he's now the originator. And some key people or chats that he had with other people are not included in that. And I quite understand that the evidence leader said there were certain messages that are not of interest. But for a consistency basis, in particular, he's been much more in communication with one particular general and as opposed to the other. But and the things that they were discussing with the other are not included. That shows a wrong narrative or misplaced the whole view of the situation. And as a result, it was my clients obtained a legal opinion from 2 SCs, senior counsels, who then are the ones that are currently working on the application in the High Court with a junior counsel based in Durban. These had to have took place as a matter of one day, having to go through this thing. And it is on that basis that if he is to come before this commission, whatever he says may not change because of, before he could make the first statement, an interim report was made. Before he could even appear, the president has already accepted that. So whatever he comes here and says may not change the narrative. And more likely that he will incriminate himself in any answer that he gives. And it's on that basis that that the applicant decided to launch an application in the High Court to restrict this commission, not to compel him to appear and not to compel him to answer any questions until pending the finalization of that application in the High Court. Thank you, Mr. Commissioner.
Thank you, Mr. Ngwato. Mr. Ngwato, I read, because I received the application only this morning, I read it hurriedly and I may have either missed or misread what I'm about to raise. I don't remember in the affidavit a point being made about WhatsApp chats that appeared to have been initiated by the witness when in fact they were not. Did I miss that? Or is this something you are stating for the first time from the bar, as it were?
Commissioner, I was just trying to elaborate on the reasons that I given. Because the first ground of him wanting the High Court to interdict is that his WhatsApp chat should not be displayed because those WhatsApp chats are not correct. They are incorrect in the manner in which they have come from because the entire bundle of documents, they only show outgoing and ingoing. Even the WhatsApps that somebody forwarded to him, and he sent it to somebody, it only shows that he's the one sending and making him the originator, while he's the actual fact not the originator of the message.
Okay. With the exception of what you are raising from the bar, my reading of the application is that the only new thing that's being raised in the application affidavit is the issue relating to Section 35 of the Constitution. The rest is something that the applicant ought to have raised in his postponement application moved last week. Do you agree with me?
May you please repeat?
I'm saying I read the application, today's application, to raise only one new issue, leaving aside the point that you are making from the bar. And that one new issue is the issue relating to Section 35 of the Constitution, the right to a fair trial in the context of a criminal trial. That's the only new thing that I saw in my reading of the application. The rest are issues that the applicant ought to have raised in his postponement application that was moved last week. What's your comment on that?
If I understand you, Commissioner, is that the things that are mentioned in the current application, is the Commissioner saying most of them are the things that were raised in the previous application?
Are the sort of things that could and ought to have been raised in last week's application. The exception is the Section 35 issue. That, on my reading, is the only new issue.
I differ, Commissioner, and maybe let me explain myself in terms of maybe try to find out common ground between the two. When we moved the application last week, it was simply because that we had not had time to peruse. Now, the time to peruse obviously goes hand in hand in the manner in which you received the documentation. But on further perusal of the matter, these things now become very clear. That Section 35, subsection 3 rights will be highly affected. But it all emanates also in terms of how he has been served right from the beginning. So there's a lot that starts and giving context from the beginning of how he received the notices and the ultimate aspect, if I'm making myself clear.
Yes, Mr. Ngwato.
And maybe just to conclude, Commissioner, we obviously gave the client a legal advice in light of the Zuma case, and I'm quite aware that the Commissioner is quite vested with that case, if not that participate in that case. And we had to distinguish between the rights of an accused as opposed to the rights of a witness. Because you could not invoke the right to remain silent because he's not an accused in here, he's actually a witness. But as a witness that is already being charged, is more likely to incriminate himself, which now prejudices his rights. And hence the focus in terms of that is the Section 35, subsection 3 rights that could be violated.
Thank you, Mr. Ngwato. Thank you. Thank you. Mr. Shaskalsin.
Thank you, Chair. Chair, this application needs to be seen in the light of the chronology. The witness has known he has to give oral evidence at this commission since sometime in November last year. He knew about the date of 30 January more than 2 weeks ago. He was provided with all of the WhatsApps that have been made available to the commission on 22 January. That was 12 days ago. He has no basis from preventing the Commission from having regard to those chats and from confronting him with those chats. But if he wanted to do so, if he wanted to bring some application in that regard, the time to launch that application was 12 days ago. He chose not to. Instead, he delayed until 28 January, that was 2 days before his hearing date, and sought a postponement of hearing so that he and his attorney could work through the WhatsApps. He brought his postponement application on 30 January. It was moved on 30 January. By that time, he knew about the recommendation in the interim report, but he elected not to address it in his postponement application. He successfully derailed the hearing set down for 30 January and was given a postponement to today. Then this morning, he brings a new postponement application. This one is linked to a High Court urgent interdict application that he's apparently now served, and that in draft form was attached to the postponement application. According to the draft notice of motion, the High Court application is to be heard on 10 February. That's in a week's time, so it would derail any prospect of him testifying this week. The relief sought in the High Court application is framed in a confusing fashion. Prayer 1 is relatively simple, it's the urgency prayer. Prayer 2 is a prayer for an interim interdict restraining the Commission from compelling the applicant to appear before the Commission until, quote, finalization of this matter. Prayer 3 is a prayer for an interim interdict restraining the Commission from exhibiting the applicant's WhatsApps pending, quote, finalization of this matter. So 2 and 3 seem to be prayers for interim relief. And what are they contingent on? They're contingent on prayer 4, which is the prayer for final relief. And that's a prayer for an order reviewing and setting aside the notice in terms of Regulation 10.6 and the summons directing the applicant to appear on 30 January. So they want those two documents or instruments set aside. And they want them set aside because they were issued, quote, whilst having issued an interim report to the President with findings and recommendations against the applicant on 15 December, and which the President implemented on 29 January, which is contrary to the rules of evidence and principles of fairness. So it seems to be this new fair trial complaint. And that's the final relief. Now, the urgent is a complete abusive process. If it was going to be brought at all, it should have been brought long ago, and certainly before last week's postponement application. But in particular, the prayer for interim relief preventing the Commission from exhibiting the witnesses' WhatsApps is utterly hopeless, because it is completely unrelated to the prayer for final relief. Even if the witness were to obtain the final relief in prayer 4, there is nothing that would prevent the Commission from exhibiting his WhatsApps. The ordinary rules of evidence in courts don't apply to a Commission. Rule 6.1 expressly states the Commission may receive any evidence that is relevant to its mandate, including evidence that might otherwise be inadmissible in a court of law. These WhatsApps are extremely relevant to the mandate of the Commission. In my view, they are more relevant than any evidence that has ever come before this Commission thus far. So whether or not the witness ever gives oral evidence at the Commission is entitled to have regard to the WhatsApps. And in view of their extraordinary relevance, it's not just a matter of being entitled to have regard to them. The Commission is obliged to have regard to them. Having said all of that, there is another issue, which is the fair trial complaint that is advanced now is itself stillborn for two reasons. The first is the regulations and the Commissions Act make clear that the witness has a right of privilege against self-incrimination in these proceedings. So the witness can refuse to answer any question that is potentially self-incriminatory. The second is that any evidence that the witness gives in these commissions is inadmissible in a criminal trial. So the fair trial complaint is a non-starter. But despite all of that, and despite the fact that this application and the postponement application are, in our view, abuses of process, we are willing to accommodate the applicant to a limited degree. What we propose is that we will not ask the applicant to answer any questions until his High Court application is finalized. However, we will not refrain from exhibiting his WhatsApps. Rather, we will use today and the remaining days that we would have used to hear the evidence of the witness, instead to display his WhatsApps and to explain their significance. If at the end of that process and after the High Court application, the applicant wants to give evidence to refute any of the inferences that we will in the course of the next few days ask the Commission to draw from the WhatsApps, he's welcome to do so. We undertake that if he wants to come back and testify to clarify any wrong propositions that we have put to the Commission, wrong inferences that we've drawn, we will ensure that he has that opportunity. There's another issue that I should just mention, which is that he has never previously expressed any concern about not being told which of the chats are forwarded and which of them originate from him or from the counterparty. If he had, we would have given him a spreadsheet for each set of chats which says which are the forwarded chats, which are the originating chats. He now raises that complaint. If he wants that information, we're happy to give it to him before he decides whether or not to come back to testify. But what we're not happy to do is to allow the process of this Commission to be derailed again. So our submission is that this postponement application should be dismissed, subject to the condition that we will not expect the applicant to answer any questions in respect of the WhatsApps that we will be displaying today, tomorrow, and possibly later this week. Those are our submissions, Chair.
Thank you, Mr. Chaskelson.
Mr. Chaskelson, can I just to clarify, I mean, if a postponement is refused, the witness is not excused. He has to remain in attendance, otherwise we are confusing. We refuse a postponement and then we excuse him. If it's refused, it seems to me that he would have to remain in attendance until he's excused by the chairperson. But if he remains in attendance, sitting, which I think he must, sitting in the witness box, it's entirely up to him how he wants to participate. Yes, he will be sitting remotely as was permitted with the last application. But as long as he remains in attendance, you will do the exercise, you will do your presentation as you wish to do, and it is really up to him how he chooses to participate, because if he should decide as he's sitting there that he does want to engage with what you are presenting, we obviously can't stop him. But I just want I want to be clear about that a refusal of a postponement, it doesn't follow that he gets excused. He's given leave to leave the commission. It means he remains in the commission until the chairperson says otherwise. And you're not suggesting that if that happens, if he remains in attendance, you will simply present he shouldn't participate in the process. You're not saying that.
No. If he is entitled to participate as much or as little as he wants to.
Thank you.
Mr. Mwato, if you have any reply, but there are two specific issues that I would like you to respond to. First, the point made by Mr. Shaskalsin that the Section 35 point is still born for the reasons that Mr. Shaskalsin gave. I'm sure you remember them. And then, secondly, the exhibition of the chats and commentary on them, which is how Mr. Shaskalsin proposes to proceed today. So your comment on both those and whatever other reply you may wish to make, please.
Thanks, Commissioners. Commissioners, there were 4 aspects that I wanted to respond to based on the statement by Mr. Shaskalsin, and 2 of them actually emanate from the same aspect. The first one is that he says he's been aware of this when he was invited, and if he wanted to bring about an urgent application, he could have done so, even including in last week. And just to clarify that particular aspect, the applicant could not in any event, in anyhow, could have been aware and could have therefore acted therefore. When the interim report was issued on the 15th of December, before he could even submit his first statement, he was not aware of the interim report. And the interim report is a confidential document that goes to the president. Nobody has an access to it. So he could not in any way been aware of the recommendations and findings in the interim report. Second to that is that even last week itself, I indicated in the last postponement application that just in the midst of preparation on the 29th, a day before, that's when the president made an announcement. And in that announcement, his name for the first time appeared. It is the only first time ever that he became aware. That was the night before he could appear in the commission. And the second to that, or to support that, when we appeared on the commission on the 30th, we said, we have received this 4,800, now reduced to 1,300, but we have not yet finalized studying the documentation. So he could not have at that time appreciated what his rights and what his rights are, because he had not even gone through the documentation. So it is incorrect to then suggest that had he wanted to bring this thing, the matter, he would have done so, and therefore there is no urgency in the matter. And that's the part that will be argued in the High Court in terms of when did whether the matter is urgent or not. That's the first comment with regards to the comments about urgency and when he became aware of that. The second aspect will also go together with the Section 35, subsection 3, in terms of the right to a fair trial. Is that now that he has have gone through the WhatsApp charts and now appreciate the veracity and the implications brought by these WhatsApp charts that he has now finalized yesterday, it became quite very clear that whatever answer, especially in light of this recommendation has been accepted, whatever questions they pose or whatever WhatsApp they display will implicate him in the next criminal proceedings that have already been approved by the state president, whether it's criminal proceedings or internal. So it greatly then affects the right to a fair trial in terms of him being able to, him possibly implicating himself. But also, I indicated that these WhatsApp charts, in the manner in which they've been extrapolated, which now the evidence says if there's a need for that, they could provide. They've been extrapolated or in an incorrect manner. And I gave an example of a WhatsApp that has been forwarded to him is now being portrayed as he is the originator of that WhatsApp. So even if you display them here, it will be misleading the country because it's going to be seen as he was the originator of that WhatsApp, whereas in actual fact he's not. And as a result of that, it then brought about in terms of whether the authenticity of these WhatsApp messages. Because how was the phone taken? What are the qualifications of the person who downloaded the WhatsApps? How truthful are these WhatsApp charts? Because in so doing again, will be a violation of his rights because we already identified quite a great number of them that they were not originating from him, but they are now being displayed as they originate from him. Now, with that being said, is that this commission will then be failing its own mandate because the mandate of the commission is that in terms of the terms of reference to their allegations, assess the information, and then make a determination if there's a prima facie evidence against a particular person. In this particular instance, decisions have already been made, recommendations have been made, but more importantly and central to that is how these WhatsApp chats have been obtained from his phone. It must also be remembered, Commissioner, when he received the first notice, it was not about WhatsApp chats from his phone. It was WhatsApp chats from somebody's phone. That's when he received the first notice and the summons. The only time he now receives WhatsApp chats from his own phone, and the evidence leaders testified about that, how they struggled to get the information from SAPS. They only got it last week, and therefore they were able to work it out. It was just last week. And therefore he could not have appreciated the nature of the WhatsApp chats any time before. He could not have appreciated the fact that he could bring an urgent application any time before until the state president makes an announcement on Thursday last week, and he was to appear the next day. And to respond to the two aspects that you said, I must maybe have a look at it. That in terms of Section 35, is the right to self-incrimination. Is that those WhatsApp chats are just the same as any oral evidence or any type of evidence. They are incriminating, especially if the source of how it has been extrapolated is highly questionable, which now portrays him to be the sender, whereas in actual fact he's not the sender. He's actually forwarding what was sent to him. He's not the originator of the message. And in terms of the terms of reference of this commission, one is that the commission need to look in terms of how criminal or drug cartels have infiltrated SAPS. And if there's a message coming from a person that perceived to be part of the cartel and sent to him or forwarded to him, and now he forwards to somebody else, and now he looks as if he's the originator of that, that makes him to be participating or having facilitated in the organized crime. So they have far much reaching implications, and hence the application to the High Court is to forbid and restrain this commission from using those WhatsApp chats pending the finalization of the High Court application. Thank you, Commissioner.
Mr. Nwatu, you've heard, and I assume that you know that to be a position of law, but you've heard Mr. Chaskalson say that anything that this witness says in this commission may not be used in criminal proceedings. So when you speak about self-incrimination, that is handled by the Commissions Act, which says, and the established law, that any evidence he gives here may not be used against him except for perjury, if he perjures himself there. So I expect that then that's not an issue. That's not a ground to avoid him testifying. That's one. Two, you make an assumption without a basis of what will be required or required of the witness to answer in any processes that the President has announced must follow, arising from what we have referred to, that there's prima facie evidence. And in fact, there's no basis to refuse to testify when you don't know, when he doesn't know how that process is going to unfold and what he will be required and expected to answer and speak to. So from where I'm sitting, your concern about self-incrimination, whether in court or in SEPS processes, doesn't seem to be grounded in law or in any known facts. And that in my view, should dispense with any concerns about self-incrimination. Two, you seem to, you're concerned, firstly, the witness seems to want to know in advance what he will be asked before it is put to him. That's how I understand the complaints, the grounds on which you're seeking this postponement from what has been said in the papers that you have filed with us here. That he wants to know what is going to be asked because the language he uses is, I'm going to be asked questions in an open-ended fashion and I don't know where it will go. And that's a repeat of a theme of last week when you applied for the postponement. It was pretty much the theme. He doesn't know what is going to be asked and it could go anywhere. But that's true for every witness. That could never be a ground, in my view, for any witness to be excused from testifying. So that's two, and you can say why I haven't heard why you say that's a ground for a witness to refuse to testify. And lastly, the issues you referred to about it's WhatsApp messages from other people forwarded to him. He doesn't know who downloaded them, the integrity, and he doesn't know the integrity of that process. But that's matters that witnesses get to speak to when they're in the witness stand. And I want also to note that there are two, from what you've said, there are two tranches of documents. There's the first batch of documents that he got previously, and my understanding on Friday of you was that he has no difficulty testifying to that. So it's not a blanket concern. Last week you said to us he has no difficulty. In fact, I remember saying to you, so we could proceed today on that first batch of documents and you wouldn't have caused a postponement. And you said yes. So your complaint doesn't relate to that. So you should be perfectly able to speak to that first batch of documents. The second batch is the 4,500 pages. Again, I'm going to repeat myself that what you're raising as matters of concern are matters that many witnesses have to confront on the witness stand, and they say, but this is not from me, it was forwarded to me, it's not mine. Those are answers that your witness should be able to give, and I don't see why that would preclude, why he would be precluded from saying that. It has not been suggested that he wouldn't be entitled to do that, but importantly, it's not grounds to refuse to testify. Thank you, Chair.
Thank you, Commissioner. I think, Madam Commissioner, you raised 4 points that I have to address and respond to. The first part being, we're making an assumption without a base that he might incriminate himself. I wish to submit with the greatest respect that the basis in which we're moving from, Madam Commissioner, and if I were to combine this aspect together with the last aspect that you mentioned in terms of the first part of the documentation. And when we approached the Commission the first time last week Friday, we clearly stated that the first part of the WhatsApp chats he received, they were not WhatsApp chats from his phone, but he was asked to make comments about it. And he had no problem in doing so, and he has since submitted to the Commission. The challenge and the problem to compound the problem was that when we now received the WhatsApp chats from him, we're given short space of time. But secondly, or on top of that, was the pronouncement by the president. Now, when the commission now states that there is no basis for him to incriminate himself, is that the president has already made an announcement that he must be charged. It is a matter of administrative process that at any given time from now onwards he could be charged. And it is true, he does not know what is going to be asked about. And if it's even worse with that, that if he does not even know what is going to be asked about, that he could be saying things in the hope of clarifying and assisting the commission whilst digging a grave for himself. And that becomes a dark room to walk into and navigate, because you're now walking into this dark room that you don't know. It even makes it even worse. But when we approached the commission last week, we never at any given point asked to be given questions. We stated that yes, he was never given questions, but we never make any demand of being given questions. Now, that becomes a problem when you now finally receive the documents and you finally study the documents and you find that the documents that has been given to you, and I don't want to suggest that this evidence that has now been given to you is being tempered to suit a particular narrative. But it then comes out clear that messages that were not sent by him are now being made to appear that they were sent by him. Because the contents, if you are to be asked about the contents of that particular message, which now shows you're the originator of that message, whatever answer you give, you are acknowledging and accepting the contents thereof. And that over and above the fact that the evidence from here may not be used against him at a particular instance, but there's beyond the right to self-incrimination that a person is entitled to. There's a right to dignity. This particular person is not just him, there's his family involved, and now a whole wrong, incorrect narrative will have been placed in the public domain, which not just affects him and his livelihood and his children and his wife. And hence, he wants to the court to interdict the use of these charts in the manner in which they've been presented to him. Because in the manner in which they're presented to him is incorrect. And he can't answer any other thing in terms of those.
Thank you, Mr. Mann.
Thank you, Commissioner.
Can I good morning, just clarify two things. I'm looking at the President's statement here. And I want you to tell me where the President says this witness must be charged. Because you're attributing to the President and to this commission things that are not said anywhere, and you're using them as a basis for a postponement application and a High Court application. I will read for you what the President said in his statement. The Commission has said there's prima facie evidence of wrongdoing, and referrals are made in respect of these people. But you making an application on the basis that there's a criminal case and somebody has been charged. But there's no basis for that. Because wrongdoing could be HR related, could have nothing to do with criminal proceedings. So don't attribute to the President statements he did not make. That's the first point. The second point is, if your entire argument is taken to its logical conclusion, especially in relation to the privilege or the right against self-incrimination, it means your client will never testify in this commission, because even in 6 months' time, there will still be a concern about self-incrimination, which means he should never come here and he should never take part in this commission, and we should just forget about it, because that's the logical conclusion. Thank you, Mr. Mwata.
Perhaps if I may just add to the first point that Commissioner Khumalo says, reading from the President's statement, the media statement, it actually also reads a task team will be constituted. The task team will institute investigations against people identified by the Commission for Investigation. So nowhere does it say your client is going to be charged and what he will be charged with. It just says a team is constituted to conduct investigations. So self-incrimination is not an issue that you can rely on at this point.
Thank you, Commissioners. I appreciate that. Let me start with the first one that Commissioner Khumalo indicated. Thank you. Thank you so much. That the statement by the President does not make any reference to any criminal case. It might as well be an HR case. But whilst we are quite very clear that in terms of the terms of reference of this Commission, the Commission is to make recommendations and findings for criminal charges and any other process. And that's in terms of the terms of reference of this Commission. So I don't think any terms of reference from this Commission can be taken less the criminal aspect as well. That's number one. Number two, even if the process may...
Mr. Mato, you're not answering me. You said in your submissions, the President said your client must be charged.
Commissioner, if
now, I was simply pointing out that nowhere in the President's statement does he say that, because the statement says the Commission has found prima facie evidence of wrongdoing and has made referrals for investigation, which is what Commissioner Baloy is emphasizing. Let's not play around with words. I mean, either you're answering what I'm saying and you address it specifically, or we don't deal with it at all. But to say you can imply other things that are not there, it's simply incorrect. You're making an application, and you're saying one of the grounds upon which the application is brought is that the day he was supposed to testify, he found out that the President said he must be charged. Either that is correct or that is incorrect. And then we can deal with the issue of self-incrimination, which, as I said, on your argument, that will always be there, which means on your argument, he should never come to this Commission and testify. So those are the 2 points. Please deal with them specifically, but let's not go around them.
Commissioner, unfortunately, sometimes there is no just a simple way just to give you a yes or no to an answer. You have to give a context to it. And giving a context to it is not avoiding answering your question, but it's just trying to clarify the issue. But what I'm trying to say to you, Commissioner, is no tax team, no investigation will not lead to a person being charged. The tax team at the end of the day, the investigation at the end of the day, because there's a prima facie evidence of wrongdoing. Wrongdoing in this instance has not been explained whether it's wrongdoing only in terms of HR-related matters or in criminal matters. So whatever way that is going to answer, there is already a prima facie wrongdoing before he could make a written submission or could say anything. And that in itself, Honorable Commissioner, is a ground for one to implicate.
Isn't that the problem? You don't know what wrongdoing has been identified. You have absolutely no idea. Absolutely not. Maybe the wrongdoing is that he exceeded the speed limit on Rivonia Road. You have absolutely no facts to base yourself on to say whatever he's going to be saying about these WhatsApp messages in the 4,500 pages will be self-incriminating. You have absolutely no basis. You haven't seen the report. You don't know what that report says about your client or this witness. You have absolutely no idea. And so you have no basis whatsoever to say anything at all that he's going to be saying here is self-incrimination. As I say, and I say it without meaning to be flippant, but to make the point that it could be that the wrongdoing that causes the President to order an investigation against him is he exceeded the speed limit. You don't know. You have no basis. This is really, honestly, a fact-devoid application. You may want to argue the legal points that you rely on, but where you want to say well, he's going to incriminate himself. Well, the WhatsApp messages, there are no facts. We don't know what those WhatsApp messages, what his explanations are for them. We don't know, and yet you want to rely on that to persuade us, the commissioners, to grant a postponement, when you are not saying to us, here are the facts about those WhatsApp messages, here's what they speak to. And so you commissioners should not allow them to be showed. I mean, that's what you do with an application. You're asking for indulgence from us. There's no order of court that says we can't proceed. So as matters stand, we are entitled to proceed. You seek an indulgence. You haven't, in this application, pleaded any facts on which we would base our indulgence, at least according to me. And I don't know that there's any, and of course subject to the chairperson, I don't know that there's
facts or law.
Facts or law, absolutely. I really don't know that there's any, we're serving any real purpose with this continued exchange. You have made your case on your papers. You've been engaged by us. You're not saying anything new to us. You keep repeating what you have said. I'm not sure where we're going with it.
Chair, with the permission of Chair.
Yes, Mr. Ngwato.
Thank you, Chair. Chair, I really don't want to appear not listening and taking the cue from the Commission. But I really have a serious problem with the following issues that there is no basis. Chair, the Commission is based on the terms of reference. The terms of reference are quite very specific as to what the Commission needs to inquire. It is not any other thing. And the specific issues that the Commission needs to inquire is to establish the following issues. One, if there's any infiltration in...
Can you please, we all know what the terms of reference provide.
So when we look in terms of the answers is to give, it is not just any other thing, whether it's a speed limit or anything else. It is specifically in terms of the terms of reference of the Commission. We serve as the basis. If they say there's a prima facie evidence of wrongdoing, that is in terms of the terms of reference of the Commission, not nothing in anything else. And it is that, Madam Commissioner, that we have looked in terms of what the terms of reference of the Commission is. We have looked in terms of the WhatsApps. We have looked in terms of the process. We have looked in terms of the answer that they have to be able to provide. Is there any possibility of incrimination? Definitely there is. Whatever he's going to come here and say, he'll be incriminating himself. He'll be digging his own grave even deeper.
All of this arises from the point made by Commissioner Kumalo with regard to what you said about what the President said. Can you please wrap up your response to that simple issue, please? Let's not open up the debate because you've addressed the debate with regard to other issues.
Yes, finally and in short, Commissioner, is that yes, the confirmation by the President tied the horse that there is, he has accepted the recommendations and the findings of the Commission. Tax team must be set in terms of to investigate, which investigation will lead to the charges, because there's a prima facie evidence that's already been established. And on that basis, that serves as the ground for him to incriminate if he continues in that particular process. Whether is he going to ever come before the Commission? Yes. After the finalization of the High Court, if the ruling of the High Court is that there is no merit, then he has to come and proceed. It's not like he's avoiding to come before the Commission. It's known in this country, if you refuse to appear before the Commission, you'll find yourself in contempt, and there are implications thereof. So he will come and appear if the ruling of the High Court is otherwise. Thank you, Commissioner.
Thank you, Mr. Ngwato. We have read the papers in the postponement application. We have heard submissions on the application. We notice that today's application is replete with a rehash of the issues that were raised in last week's postponement application. The only new issue really is the Section 35 point. The Section 35 point is answered simply by the response given by Mr. Shaskalsin and amplified or added to by Commissioner Baloyi. For the reasons given by Mr. Shaskalsin, that point is still born and therefore can never be a basis for a postponement of today's proceedings. Mr. Shaskalsin suggested a practical way of dealing with this to the extent that the witness may not be prepared to participate in today's proceedings. And that practical way is for the evidence leaders to exhibit the contested chats with what they see as necessary commentary on them. And Mr. Shaskalsin further says that if the witness is so minded, he may at a later stage come back to the commission and say, I now want to file an affidavit that responds to those issues. I now want to come to the commission and testify on those issues. That is, those issues being whatever arises from the chats that will have been exhibited and commented upon by the evidence leaders. That to me sounds like a sensible, practical way of dealing with the matter. That is, of course, if the witness insists or persists in his stance of not testifying today. But if we reach that stage, that is, of proceeding in the practical manner suggested by Mr. Shaskalsin, what we will not allow is for the witness to leave. We will not excuse the witness. The witness must remain in attendance, remotely, of course. We will not excuse him. That is, if that is the stage we reach. Now, before we make a final pronouncement, Mr. Ngwato, may I ask for a response from you? And indeed, at this stage, perhaps I might even have to engage the witness himself. Mr. Ngwato, so is the position, because the inclination is that we should proceed along the lines suggested by Mr. Shaskalsin. So is the witness's position, through you as his representative, that he will not participate and that the evidence leaders should proceed in the manner in which they are minded to proceed? What is your response to that?
Honorable Commissioner, the witness has been made available. He's since been picked up at 6 o'clock this morning. He is available. He will sit in, but he will definitely not participate. My sincere apologies, Mr. Ngwato. Can you please start from the beginning? I'm sorry. In short, Honorable Commissioner, the witness will not participate.
Will not participate.
Will not participate.
Thank you.
Because for the reasons already given, if the commission orders him just to sit in and be available, he will sit in and be available, but he will definitely not participate.
Thank you.
Make no comment.
Thank you. As I said, I think we would like to hear the witness directly as well on this, because it's a very crucial issue. I do see Witness F on screen. Witness F, have you been following? Have you heard what I've just said?
Good morning, Commissioner. I've been following you.
Good morning, Witness F. Mr. Ngwato has just said that you will not be participating, but I want to hear it from you, whether you also confirm that you will not participate.
I confirm, Commissioner.
But as you probably also heard, we as the Commission are not excusing you. We are not releasing you. You should continue being part of the proceedings remotely, even if you are not saying a word.
I confirm, Commissioner.
Witness E, but I will ask both Mr. Chaskalson and your attorney to respond. But what I must draw to your attention, we may have indicated an inclination as to the practical manner in which we want to deal with this. But we are just worried that what we are doing, which is informed by the practicalities arising from what was sprung on us this morning, may be seen to be creating a precedent for other witnesses. In terms of Section 6 of the Commissions Act, it is an offense for a witness to refuse to answer questions. So to the extent that you say that you will not be participating, the entire context being that even if asked questions, you will not respond to them, that is an indication that you upfront are saying, I am going to commit an offense under the Commission's Act. Mr. Chaskalson, do you wish to address us on this? And Mr. Ngwato, will you please respond? You've heard that, Witness F, and I hope you understand its serious implications.
Sorry, Chair, I just want to repeat on record that we will not ask any questions of Witness F. So, I mean, obviously we can't speak for the commissioners, but we will not be asking any questions. So, flowing from us, that issue will not arise.
Thank you, Mr. Chaskalson. Mr. Ngwato?
Thanks, Commissioner. I think that's much a loaded statement. Then he has nothing to answer if there were no questions to ask to him.
Although you can never anticipate that we will not want to ask questions. Mr. Chaskalson's attitude is not necessarily ours. So the point about the potential commission of a criminal offense still stands, and that's what I want you to respond to.
Commissioner, I don't think much, and this is me maybe subject to having to consult with the client and explain this clearly. I don't think he'll be committing any of that offense in that one, he has presented himself, he's here. It is as a result of the discussion that and the ruling that has been made by the Commission and the compromise that has been made by the evidence leaders that they've got nothing to ask him. That him being available and attending and not answering questions because there are no questions will be committing any particular offense. And if the commissioners may want to ask him a question, he may answer and say no comment. And still, that doesn't make him to not be responding to questions because he can answer much simply to any other question. And I'm not trying to influence him not to answer any question. He may simply say no comment because I've not had a legal advice or I'm not happy with the manner in which things have been. He could simply say no comment, and that in itself does not make him to be committing any crime in terms of that particular section. Thanks, Commissioner.
Mr. Ngwato, you and the witness may well be advised to look at Section 6 of the Commissions Act. Nothing precludes us commissioners or any one of us to ask questions of this witness. Whatever Mr. Chaskalson may have decided, whatever approach he may have decided to adopt, nothing precludes us from doing that because we are the investigative body, the commissioners. And Section 6 says a witness who has, having been sworn, fails to answer fully and satisfactorily any question lawfully put to him. I want you to be mindful of that, whatever you advise the witness, as you're entitled to do, that whatever arrangement or whatever approach adopted by Mr. Chaskalson does not insulate him from questions from the commissioners, but it also doesn't insulate him from the legal obligation that arises from the Act to answer fully and satisfactorily questions that we lawfully put to him. I just wanted to point that out to you.
I appreciate it, Commissioner. Any answer given by the witness does not have to satisfy the commissioners. If no comment is equally what he wants to say, that is his answer.
I'm not opening a debate. You said something that I thought you seem to not be aware that his obligation is to answer fully and satisfactorily. Whether to say no comment is to answer fully and satisfactorily is a determination that we will have to make. It's the simple point that I'm making to you. So I'm not asking you to comment, and I'm not inviting an engagement. I'm just pointing out that as you advise him, including if you're going to say to him, as you have suggested, he may choose to do, to say no comment, ultimately it's for us, the commissioners, to determine whether a no comment is to answer fully and satisfactorily questions that we have asked. That's a simple point I was making.
As the commission pleases.
Thank you. Thank you, Chair.
Chair, can I just clarify, is Mr. Maleka or another member of Mr. Mwato's firm present with witness F at the moment? Because there are issues under Section 3(4) of the Commissions Act, which gives witness F a privilege against self-incrimination if he's asked questions. And I just want to clarify that there will be legal advice available to him where he is.
Mr. Mwato.
Thanks, Commissioner. Unfortunately not. We were all divided in terms of other team members have been at the High Court this morning, as I indicated, and Mr. Maleka is here with me. So the witness, unfortunately, is not with any legal representative from our law firm where he is right now. He is at the offices of the attorneys. Okay.
Didn't get that shit.
Why can't Mr. Maleka be with him?
Well, that would mean for us, for Mr. Maleka to be with him, we have to stand down. But preferably, the leading attorney on the matter, I would prefer that I'm the one that's supposed to be with him than Mr. Maleka. And that would mean that I have to travel to wherever he is.
No, if need be, we would rather have to call him or something. I prefer, and I think this is shared by my co-commissioners, I prefer that you should be here with us in case there is a need for engagement and interaction. I prefer that you should be here, not somewhere remotely.
On that basis, Commissioner, may I ask that we stand down so that I can make necessary arrangements?
We were going to anyway.
Okay, thank you so much.
So we won't indicate for how long, we'll just indicate when we are ready. Let us adjourn.
The recording has stopped.
What? What? Huh? What? Huh? Oh. Okay. Let's put it down. That's fine.
just to let you know, if you haven't had time to gulp your tea, you have another 15 minutes. We'll resume at 11:30. Thank you. right, we are ready to resume. I know it's 2 minutes before what we promised, but we're good to go. Your cell phones off, please. Thank you.
The following order is made. 1, the application for a postponement is refused. 2, the evidence leaders are granted leave to present as evidence the WhatsApp chats that relate to witness F and, when necessary, to comment on them. 3, witness F is ordered to remain at the remote location from which he is supposed to testify until he is excused by the Commission. That's the order. Having so ordered, we cannot allow witness F to get a free ride in the face of the provisions of Section 6 of the Commissions Act and Regulation 8.1, both of which create an offense for refusing to answer questions at the Commission. So, Mr. Shaskalsin, we direct you to put no less than 4 questions to witness F. Depending on his answers, he may expose himself to a possible criminal charge under Section 6 and Regulation 8.1. Also, my reference to at least 4 questions does not mean that if we, the commissioners, or anybody participating in these proceedings, or in future for that matter, may not put questions to witness F. There is questions additional to the 4, the minimum of 4, that I am directing you to put, Mr. Shaskalsin.
Chair, can I choose when in the sequence to put those 4, or do you want me to start with 4 questions?
I prefer that they follow each other so that we know where we are with the witness. I don't know whether you would be ready to do that or whether you would want to, or rather I would prefer that we take a 2-3 minute agenda.
No, I'm ready to begin.
Before you continue, Mr. Shaskalsin, as we took a bit of time before, Mr. Ngwato, we took quite some time considering the order and we debated it amongst ourselves, but it has just occurred to us now that the order does not cover everything it should cover. Paragraph 2 of the order should relate also to the evidence leaders being granted leave to lead whatever other evidence, even if that evidence is not WhatsApp texts or WhatsApp chats, because we would imagine that there's the possibility that there is such evidence as well. So we amend paragraph 2 accordingly.
Thank you, Chair. I've been told that the witness's attorney has not yet arrived at the premises. Maybe if I can defer my questions until a later stage so that the witness's attorney is present.
That's in order. Let's start with what you are able to start with.
Thank you, Chair. I'd like to start, let's first start with housekeeping. There should, in front of you, be 3 different bundles.
Just a very important procedural step, Mr. Shaskalsin. Witness F, are you there? Yes. You've heard our order, have you?
Definitely, I've heard it, your order, Commissioner.
I'm sorry, I can't hear you.
I heard it, Commissioner.
Oh, thank you, thank you, thank you. Now, you've also heard that questions are going to be put to you, whatever your answer will be. So we cannot expect you to answer questions. Of course, we don't know what your attitude to the questions will be, but we cannot expect you to answer questions not having taken an oath. Will you swear or will you affirm? Because I want to administer the oath at this stage.
I swear.
So you will, all right. Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much. And I do not remember if I greeted you. Good morning, Witness F.
Good morning, Commissioners. I greeted you earlier. I assume maybe Commissioner forgot, maybe AG and so forth. Thank you, Commissioner.
Mr. Ngwato, are you fine if we... That look, Mr. Ngwato, seems to speak volumes. Perhaps I should not even say it's a look. It's like you are glaring at me. Mr. Ngwato, are you fine if we proceed, or would you rather we wait until your colleague has arrived at the location the witness is testifying from?
I'm fine on the following basis, Commissioner, that there will be no questions for him to ask until such time. It is just as the Commission ruled that they will display messages.
All right.
And I suppose maybe by the time questions are raised, Mr. Maleka will have been there. So on that basis, that it's just going to be watch and show.
All right. Thank you, Mr. Ngwato. Thank you. Please proceed, Mr. Shaskalsin.
Thank you, Chair. Can I just clarify that there should be at least 3 files in front of you, a statement bundle, or behind you, an exhibit bundle, and an annexure to exhibit bundle. And Witness F, can I ask that on your side also you check that you have those?
Just a moment. The last one is 2 files. So the one you say is exhibit annexures to exhibits bundle. It's 2 files, not 1.
So then there should be 4.
Yes. 5.
This is not an auspicious beginning.
Can you please assist me with the numbering? For example, I have here exhibits bundle, file 1 of 4.
Yes.
So, okay.
Up to 4.
Up to 4. So, I have 1 up to 4. Thank you. Exhibits bundle. Okay.
Ms. Chaskasin, can I repeat so that we are on the same page? We have the statement file.
Indeed.
And then we have the exhibits bundle, which is file 1 of 4. And then we have exhibits bundle, which is file 2 of 4. And then we have annexures to exhibits bundle, which is 3 of 4. And then we have annexes to exhibits bundle, which is 4 of 4. So it's 5 files in total. Maybe yours are different, but
we have the same documents organized differently.
Yes, Mr. Chaskalson.
And witness, can I just clarify that you too have those 5 different files, one file called statement bundle or statement file, one file called exhibit bundle 1 of 4, another file called exhibit bundle 2 of 4, another file called annexure to exhibit bundle 3 of 4, and a last file annexure to exhibit bundle 4 of 4.
Yes, I confirm.
Thank you. Can I have that as one of my 4 questions? Can I then ask if we go to
Commissioner.
Page 320?
Sorry, Mr. Chaskalson, I think Mr. Ngwato has something to say.
Just on the bundles, maybe if Mr. Chaskalson could have just assist. I don't have 5 bundles, I've got 3 bundles. But maybe just in terms of the index and pagination, what's the total number of pages? Then I'll know where we are, because I've got 3, not 5. The index and annexes exhibits is until to page 538.
That's correct. And so I understand that the commissioners and the witness will have those 538 pages split between 2 files. But it is, the pagination is the same, 538.
No, I just wanted to confirm, because we were never given files, or files were never delivered to us. We were given a link, and from the link we printed. So we didn't print in terms of 5 files, but in terms of the index, we'll confirm whether we say we have the same thing. Because the second bundle will be 795 as the total number of pages for index and exhibits.
That's the same for me.
Okay. So that the witness doesn't get confused as to file 4, file 3, and he doesn't have file 4 to file 5. He only has 3 files in front of him.
Okay. Well, but we will then as between me and the witness, I'll refer to the index to exhibits file, which is the 795-page file, and the exhibit file, and then the annexures of exhibits, which is the 538-page file.
Thank you. As long as we stick to page numbers, then you'll be able to follow easily.
Thank you, Mr. Ngwato. Yes, Mr. Chaskalson.
If we can start on page 320 of the exhibits file. And there at page 320 on the 5th of July 2023 at 18:43:47, General Sabia sent you an address. I don't want anyone to mention that address because it's a private address, and it's redacted here. But if you want to confirm, that's the private address of General Sabia. If you don't want to confirm, I won't have that as, I'm happy to make that the second of my questions. But I'll put, for now, I will put it that that is the private address of General Sabia. And after some time, that private address was sent to you at 1843. At 1902, you responded, "I'm here at the gate." And just to clarify that it is indeed the private address of General Sabia, I'd like you to go to the annexure bundle, the annexure to exhibits bundle at page 145. And if you put that address into Google Maps, this is the image that is generated. And if you go to the preceding page, at annexure page 144, you will see a picture of the news coverage on the day that General Sabia's house was raided. And if you compare 145 and 144, you will see that they are the same property. Don't need you to answer anything in that regard.
Mr. Chaskasan, should we not just get him to confirm if that is so? Or you consent that
I'm happy. He doesn't have an attorney present with him. I don't think this is a contentious question, but I don't. I said I wouldn't ask him to.
I think let's have.
I confirm is the address, Commissioners.
Thank you.
And I confirm also that my attorney is present with me now.
Thank you. If we can then go back into the exhibits bundle and to page 46 of the exhibits bundle, and I'm interested in a chat or message that you sent to Kat Matlala on the 4th of March 2024 at 8:21. You sent a contact card, and at Annexure 9, Annexure to Exhibit Bundle, page 9, that contact card is exhibited, and it is a contact card for General Sabia with a phone number of General Sabia. And the question I would ask you now, if you want to assert your right of privilege against self-incrimination, you must do so, is did you introduce Kat Matlala to General Sabia?
No.
Thank you.
Mr. Chaskasan, we don't have a context of this. When I look at this page 46, it's not obvious to us as part of the record that there's anything here that comes from the witness.
If I can just clarify.
If you could just locate, what are we looking at?
So if one goes to 46
Yes,
at 82107,
yes.
There is an icon that says VCF.
Yes, I can see that.
That is a contact card.
Yes. Now, I'm raising a different point. You've said to him, this is what he sent from him, but it's not apparent that this is material from his phone. That's the point I'm making, that for purpose of the record, are we looking at
what we are looking at
of his phone?
Is an extract of a series of all of the chats that were found on his phone between himself and one of the numbers used by Mr. Matlala.
Okay.
And in fact, the index to that bundle explains what each of these sequences of chats are. So it may be useful to just quickly at the outset run through that index. Just display at the top.
And Mr. Chasselson, seeing that witness F was prepared to confirm something, who knows, maybe he might be prepared to confirm even this as well. But go ahead.
Let me go to the...
Yes.
I'd like to get to the index just so that we can clarify everything.
Yes.
And I just want to be on the same page. So at the front of the exhibits bundle, there is an index to the 795 pages of that bundle, which describes, well, the first 35 pages are correspondence. Thereafter, from page 36 onwards, there are indexed a whole series of chats extracted from the WhatsApps on your phone between yourself and various people. Can you confirm that what one sees on the index actually is what one sees on the bundle, that the index accurately reflects the bundle that it describes?
I confirm.
Then if we go to back to the bundle, we've seen that on the 4th of March, you who always, and can you confirm also that in these chats, you always appear on the right-hand side of the page and the counterparty always appears on the left-hand side of the page? Whether or not you are forwarding a chat or originating a chat, the counterparty is on the left and you sending or forwarding are on the right.
I confirm.
Thanks. Chair, I think I've got through my 4 questions. So I will, Witness F, unless you want to intervene going forward from here, I'm just going to put things that if at any stage you want to intervene, please feel free.
Mr. Chaskalson, for my benefit, reference to outgoing and incoming, I thought that's what the issue was. So can you just clarify for us what outgoing means and what incoming means, so that when we look at all the WhatsApps, at least we have an idea?
Certainly. So the chats that appear on the right-hand side of the page are messages that are sent from the witness. They are outgoing from the witness's phone. The chats on the left-hand side of the page are messages sent by the counterparty. So from the witness's perspective, they are incoming. Frequently, you will see empty bubbles. Those reflect voice calls. The outgoing and incoming remains the same. So if the empty bubble is on the right-hand side of the page, it's a voice call initiated by the witness. If the empty bubble is on the left-hand side of the page, it's a voice call initiated by the counterparty.
You confirm that as well, Witness F?
I confirm, Commissioner.
Mr. Chaskalson, you said that's your 4 questions, but that does not address the issue why we made reference to at least 4 questions. We made reference to that in the context of the witness having said, I am not going to answer any questions. So here he has actually answered the questions. So we have not reached a point where he says, I'm not answering that, I'm not answering that, I'm not answering that.
I certainly accept that, Chair.
Yes, because he will only be within the Section 6 and Regulation 81 net once he has said, I will not answer that.
Indeed, Chair, but I did make an undertaking to the witness, and I'm not going to go beyond that undertaking. Witness F, if you want to jump in at any point, please feel free, but I will not ask you questions going forward. Further questions.
We directed in so many words that you should. So it's a direction from the Commission, Mr. Chaskalson. Because point is, yes, from where you are sitting, it's a practical way of just quickly having the evidence before the Commission. But this Commission would create a bad and unfortunate precedent if we were to proceed along the lines of just letting a witness say, I will not be answering any questions, without anybody putting specific questions to him. If an attempt were to be made down the line to bring criminal proceedings against him, he will easily say, but who put what question to me? And to what question did I refuse to respond? And he will be found not guilty and discharged. That's a precedent we do not want to create.
Chair, if you're instructing me, I will ask questions, but it is also a tricky situation, Chair, because if I am just going through the chats, I will do it in one way. If I am questioning the witness rigorously, I will do it in another way. In some respects, I will follow the procedure of just going through the chats, because I think that is the easiest way of organizing the material. There will be occasions when I will have to ask the witness, or I will ask the witness to clarify questions, but for the most part, I will be putting to you what the chats say.
Perhaps what I should do, I hope my co-commissioners agree, is not to insist that you ask 4 consecutive questions as you go along. We want to see you ask questions, and we want to see the witness's response. If his response is that I will not answer, then he will be within the Section 6 and Regulation 81 net. The simple point is we do not, and colloquially, want to give him a free ride on this. Thank you, Mr. Chaskalson.
Thank you, Chair. Can we then go to page 48 and start at 6:47 in the morning? 48 of the, unless I mention, all of my page references are going to be to the exhibit bundle where I'm referring to specific annexures. I will mention them. So at 6:47, there was a voice call from Kat Matlala to yourself. That was followed at 6:52 by a message from Mr. Matlala saying, call me. You called back at 7:22. Mr. Matlala then sent you a voice note, and I'd like us to play that voice note. That voice note was sent at 7:24 in the morning. Chair, we have some technical difficulties here. I need that for this. Sorry, come help me out. Where?
Yes, Mr. Shackleton.
Let's see if this works. If not, we might ask for a 5-minute adjournment just to sort out our flighting.
All right.
Sorry to bother you so early. If you could just send me a pin drop where it must go to.
Can I play that again?
Sorry to bother you so early. Can you send me a pin drop to where the box, to where the impalas must go, please, sir? If you could just send me a pin drop where it must go to.
I'll play it a third time.
Sorry to bother you so early. Can you send me a pin drop to where the box, to where the impalas must go, please, sir? If you could just send me a pin drop where it must go to.
Can you describe what that voice note was about?
First tell us, sorry, witness, first tell us who's speaking and then respond to Advocate Shackleton's question.
Commissioners, the person who's speaking in that voice note, I don't know him. It was the message that was sent to me. I can't remember by who. For now, I can't answer that who exactly was that in my letter.
Yes, Mr. Shackleton.
Can I then ask you to go to page 214?
Mr. Shackleton, can I just confirm with the witness what his answer means? Witness F, Mr. Shackleton put to you that this note was sent to you by Mr. Madlanga, and I think you have said you can't remember who sent it to you. Does that mean you don't confirm that it was sent to you by Mr. Madlanga?
That's correct, Commissioners.
Thank you.
Well, witness, if I have to put it to you that it was extracted from the chats between yourself and Kat Madlanga. So what I played there was the voice note that one sees in the extracted chats at page 48 of the bundle, where there is an icon that says Opus. That is the file that is in the chats, and that was played aloud.
And remember, in that context, Witness F, that you did confirm not so long ago that what appears on the right is from you, and that what appears on the left is from Mr. Madlanga. Or rather, the counterparty. Who was the counterparty here? Was it not Mr. Madlanga?
It was Mr. Madlanga, Commissioners, I do confirm. However, maybe it was a human error by saying I don't know where did it come from. Actually, I stand by my words of saying I don't know who the person was talking is. But I do confirm it was sent to me by Mr. Madlanga.
Commissioner, just for housekeeping issues, can Mr. Shackleton, when he says page 214 of which bundle? Because I tend to be running behind and looking for where 214 is in which bundle. Because
Mr. Ngwato, unless I say otherwise, it will always be the exhibit bundle. So For them, almost without exception, I will be referring to the exhibit bundle. Occasionally, I will refer to the annexure bundles. If I refer to the annexure bundles, I will say annexure bundle page such and such.
Please, thank you.
On ours, Mr. Ngwato, this is flagged as CJC 64. Am I?
That is correct, Chair. It is, but Mr. Ngwato has the whole exhibit bundle in one file.
Okay.
But if we then go to page 214 of the exhibit bundle, and you'll recall that it was at 7:24 that voice note arrived on the 21st of March. Well, at 7:24 and 55 seconds on page 214, you will see that you forwarded that voice note to General Sabia. And let me play that file again.
Perhaps, Mr. Chaskalson, because we were dealing with Mr. Matlala's chats earlier, if you could just draw the witnesses' attention to where exactly his and General Sabia's chats begin, so that he will know that the counterpart he's corresponding with is indeed General Sabia.
Chair, the names are on the chats. So on 214, you'll see on the right is the witnesses.
Yeah. No, I see.
Sort of chat name.
The name is there throughout.
And on the left is, it says General Sabia, Deputy National Commissioner.
Thank you. I see that.
Chair, we're going to have one last try, failing which we're going to have to ask for a 5-minute adjournment to sort this out.
Sorry to bother you, sir. Can you send me a... Ask to whether it Paras must go, please, sir. If you can just send me a pin drop where it must go to.
So that's the same voice note. It's the unknown man asking you to send a pin drop or asking someone to send a pin drop where the impalas must go to. And that voice note was forwarded to you by Mr. Matlala, and you have immediately forwarded it on to General Sabia. Can we then go to the next chat on page 214, and it's a message from you to General Sabia 29 seconds later at 07:25:24, and you say, "Morning, it's from Cat." Then the next chat is at 8:39, still on page 214, and it is a call from General Sabia to you, a voice call on WhatsApp. If we then go back to page 49, we see that there are a series of calls between yourself and Mr. Matlala from 9:48:50 through to 9:53:24. Page 49. So from 9:50, at 9:48:50 you call Mr. Matlala. At 9:52 he calls you back, and at 9:53 you call him back. And then the important message is the message that comes from him at 10:36:40. And can we show that message, which is in the annexure bundle at page 12? And it's a message, it's a screenshot of a message from someone called Rudy Farm Manager. And bear in mind that this screenshot is sent to you by Mr. Matlala. And so if it originates on Mr. Matlala's phone, we can infer that just like in the chat streams that we see for you, on the right-hand side, the messages come from Mr. Matlala. On the left-hand side, they come from Rudy Farm Manager. At the top of the page, just underneath the name Rudy Farm Manager, is a document which we cannot see. It's a PDF file. It's half cut off. It was sent by Mr. Matlala at 06:03. It's followed by a message from Mr. Matlala that says, please check your account again. Rudy Farm Manager then says, thank you, sir, I got it. Thank you very much. Thanks, sir, we'll do that. That's at 6:06 and 6:12. There's then an image of a voice note that was sent at 6:24, to which we can't access that voice note because what we have is a screenshot, not the original messages. To which Mr. Matlala responds, okay. And then Mr. Matlala forwards a PIN to Rudy Farm Manager. And that PIN designates the home address of General Sabia, does it not? Well, it is the same address that you confirmed earlier to be the home address of General Sabia. The response...
Witness F, do you wish to respond?
Yes, Commissioners.
Do you confirm? Do you confirm that the address is the address of General Sabia?
That's positive. I confirm, Commissioner.
And then Rudy Farm Manager responds, thanks, sir. Hi there, sir. Okay, everything has been arranged. He will catch the impalas on Sunday and transport it Monday to that location. Is it good? And Mr. Matlala responds, no problem. Mr. Matlala's response is at 10:35 on this screenshot. If we go back to page 49, we see that at 10:41 on the same day he called you. Now, when we were dealing with the evidence of Mr. Mokgotsi some time ago in this commission.
Mr. Chaskalson, before you do that, I'm getting lost here. You, at page 12, you say this is Mr. Matlala and the witness. Where do we see that? There are no numbers, and he hasn't confirmed that, he confirms the address, but he hasn't confirmed what you've put, that this is an exchange between him and Mr. Matlala.
Sorry, at page 12?
Yeah, the Rudy Farm manager exchange. I think you said this is an exchange between the
what
witness.
I put to the witness is that this was a screenshot that was sent from Mr. Matlala to him. And the screenshot, as it emanates from Mr. Matlala's phone, would have Mr. Matlala's messages on the right-hand side and the counterparty, who is Rudy Farm manager, on the left-hand side.
Okay. Am I the right page 12?
Yes, that's the Annexure page 12 screenshots. Annexure page 12. So that is the screenshot that was sent at 10:36 on the 21st of March. That screenshot was sent from Kat Matlala to the witness.
Okay, and this was extracted from Mr. Matlala's phone.
No. Well,
It's page 12.
Page 12 is the screenshot that is found on the witness's phone that was sent to him by Mr. Matlala on the 21st of March, 2024, 10:36.
I see, yes. And the witness confirms that.
I didn't understand the witness to object, but Witness F, do you confirm that that screenshot was sent to you by Mr. Matlala at 10:36 on the 21st of March?
I can confirm as to who it was extracted from, either from me or from Mr. Matlala, but I do confirm that I know the message.
Okay, thank you.
Now, just to contextualize what we're looking at here, when we heard the evidence of Mr. Mokgotsi, we looked at the chats between Mr. Mokgotsi and Mr. Matlala. And in one of the chats, Mr. Mokgotsi was taking Mr. Matlala to task. Sorry, Mr. Matlala was taking Mr. Mokgotsi to task and accusing him of having leaked to other people that he had paid for Impalas for Sibia, that he had given Impalas to Sibia. Now, it seems to me that what we see in these chats actually confirms that indeed Mr. Matlala did arrange for the delivery of Impalas to Mr. Sibia, having paid the necessary price into the account of Rudy Farm Manager, who was the person who delivered those Impalas. Do you have any comment on that?
I can comment on that because during my communication with Mr. Matlala, he never indicated to me as in whether he's paying for the Impalas or Mr. Rudy Farm. So I cannot comment on that, Commissioner, because I have no knowledge of that.
Well, can I take you back to page 12 of the Annexure bundle then?
This meeting is being recorded.
I'm on page 12 now.
If you see the top, there is a page, there is a one-page PDF attached to the message, but we don't see that. Underneath it, Mr. Matlala says, please check your account again. And then Rudy Farm Manager says, thank you, sir, I got it. Thank you very much. That looks very much to me like Mr. Matlala is paying money to Rudy Farm Manager. Can you comment on that?
It looks like that to myself as well, but it was not a communication between myself and Mr. Matlala. It was a communication between Mr. Rudy Farm Manager and Mr. Matlala. Therefore, I cannot comment on that.
You were the go-between for Mr. Matlala and General Sabia on this arrangement. You were the one who sent the voice note to General Sabia and who then received the instructions that Mr. Matlala had given Rudy Farm Manager to deliver at General Sabia's address. What did you understand was going on?
To be honest with you, Commissioners, I did not ask what was going on there. I just received such message from Mr. Matlala, and then I immediately forwarded it to General Sabia without even asking questions of what was it for. Thank you.
But why did you know that you had to forward it to General Sabia? There's nothing in the texts that says please forward to General Sabia.
Can you repeat that, Mr. President?
Mr. Shatterson, he asked you to repeat the question.
I'm sorry. How did you know that you had to forward this voice note to General Sabia? There's nothing in the messages that says, please forward to General Sabia. Well, there's nothing visible in the messages.
I think it came through the phone call.
So Mr. Matlala essentially, according to your evidence, said, I'm going to send you a voice note. Please will you send it on to General Sabia?
A screenshot.
I can't comment on that.
I think you said voice note screenshot.
No, I'm talking first about the voice note because the document that the message that is forwarded to General Sabia is the voice note saying, where must I deliver the impalas?
Yes.
So in the conversation between yourself and Mr. Matlala, in anticipation, or at 7:22, because there was a call at 7:22 before the voice note was sent to you at 7:24, and bear in mind you forwarded it on at 7:24. In that conversation of 7:22, your recollection is Mr. Matlala would have said, I'm sending you a voice note, please forward to General Sabia.
I assume he might have said that. But I can't really remember, but I can confirm I've spoken to him before this message.
And did you know that he was in the process of arranging for impalas to be delivered to General Sabia?
I did not know, Commissioners.
But then you received this voice note that made it clear that he was arranging for impalas to be delivered to General Sabia.
I can't really comment on that. He made it clear that he was arranging impalas for General Sabia, but I can confirm that he made a call and then he sent this voice note to me. But if there was any arrangement, I did not know of that.
But why, if Mr. Matlala is making an arrangement with General Sabia, would he do it through you? Why would he send the voice note to you and ask you to forward it to General Sabia as opposed to sending it directly to General Sabia?
To answer that question, Commissioners, I think that call, one of the things, I'm just assuming because it happened for quite some time, I think maybe it was one of the reasons that he sent it to me because of he could not get hold of General Sabia.
But he already...
Okay, carry on, I'll answer after you.
Sorry, but if you go back to the annexure bundle on page 9, read with page 46 of the exhibits bundle, you had actually given him General Sabia's number on the 4th of March, which was more than 2 weeks previously. So if he wanted to contact General Sabia directly, he knew how to do it. You'd given him General Sabia's number.
Can I comment on that?
Yes, please, Witness F.
Okay, Commissioners, one of the reasons that I assume that Mr. Madlanga sent that thing to me, it was because maybe he did not get hold of General Sabia.
But
that's why he sent it to me.
But could he not just have sent the voice note to General Sabia in the same way that he sent the voice note to you? He didn't need anyone to pick up the phone. He just needed someone to receive a voice note.
Thank you, Commissioners. If your phone is off or you are offline, when you send something on WhatsApp, it will only keep one line. So I assume maybe General Sabia's phones were off.
Can I put another possibility to you? Let's go back a day from the 21st of March. Let's look on the 20th of March on page 47. And at 12:49:27, you'll see that Mr. Madlanga sent you a case number. Case number's been redacted. I'm not sure that it's necessary for the case number to be redacted. But you presumably can see what case number it was. And then if we go over the next page, at page 48,
yes.
A few minutes later, at 12:52, you sent a text back saying station. Which police station? Because as we know now, each police station has its own set of case numbers. And Mr. Madlanga came back saying Mamelodi East. So he had sent you a case station from Mamelodi East. If we then go forward to the 21st of March again, after he sends you the voice note about the Impalas.
Yes.
At the foot of page 48, at 7:44 in the morning, well, let's maybe go back one chat. He sends you the voice note. At 7:37, there's a call from him to you. At 7:44, he sends up a message. You didn't send anything here. In other words, he's following up saying, why haven't you sent me what you should send me? You immediately respond over the page, 49 at 7:44:23, so that's 9 seconds later, by sending an image of a screen. And that screen is at page 11 of the annexure bundle. And that is an SAPS screen of case number 15703 of 2024 in Mamelodi East. It tells you who it was allocated to, when it passed hands to a different investigating officer, and who is responsible for that case. And it gives the name of the detective who's responsible for that case. Is that correct?
That's correct, Commissioners.
What was Mr. Matlala's interest in this case, and what was your reason for WhatsApping this screen to him?
Thank you, Commissioners. The reason Mr. Matlala sent this to me, it was actually a complaint. According to him, when he phoned me, he said one of his employees, that was a female employee, was being abused by her husband, and when she opened cases, there is no movement. Therefore, as a proxy of that female woman, he asked me to check the progress of that particular case. That is when and how I've sent in these screenshots.
Witness F, I think you know that answer is false. Do you want to reconsider it and tell the Commission what case 15703 of 2024 was really about?
I still stand by my answer. That is what Mr. Matlala told me, Commissioners.
And you didn't make any inquiries yourself?
I did not, Commissioners.
Well, what the evidence will be is that this case, 15703 of 2024, involved the murder of Kabelo Richard Mate, who was murdered outside a four-room house in Mamelodi Sector 1 and at a crime scene where 50 cartridges were found. There was no private complainant at all. The complainant was the constable to whom it was reported. And I put it to you that this looks very much like a case in which Mr. Matlala's query would have been made on behalf of a perpetrator and not on behalf of a victim. What is your response to that?
My response to that, Commissioner, I would have not known what you're putting to me now.
And you didn't bother to find out what case 15703 of 2024 at Mamelodi East involved?
I did not know. I did not do that, Commissioners.
And before we leave this Impala topic, I want to take you...
Even before you move further, can I just ask about this page here? Witness F, this is an SAPS record that you obviously had access to. What do you mean you didn't know what it was about if you had access to the SAPS record? Because that's the only way you could have been able to forward this. It's part of a record.
That's correct, Commissioners. The reason that I did not know, I've sent it, I forwarded it to someone else as well, because at that particular time, I did not have an access to the SAPS system. That is the reason I have forwarded it to somebody else.
What do you mean that's the reason you forwarded to somebody else? What did you forward to somebody else?
I did forward that case number that Mr. Matlala forwarded to me.
Yes, you forwarded it to somebody else, and what happens?
That is when they checked for me. As you see there, on top it says warrant officer, so I did not check on the system because of, at that particular time, I had no access.
Yes, and you say then you, if it is true, if we accept that this came to you from somebody else, and because you didn't have access to the record, when you send this to Mr. Matlala, why are you sending this? He's just given you a case number on what we see in the earlier page. He gave you the station. Why are you sending him the name or the name of the people or the person who's dealing with the matter. He's not the complainant in the matter. Why are you giving him the name of the detective who's dealing with this matter?
As I've said earlier, Commissioner, according to him, he was a proxy of that particular person who was being abused. And little did I know that it was a murder case, as Mr. Chagasin is bringing it forward now. I just called it and then gave him back the report because of, according to him, he was the proxy to that person.
What do you mean he was a proxy? Can I just go to as a proxy to a substation and say, give me the details of a case docket? I don't understand. Well, maybe firstly tell us about that SEPS process, but also explain what you mean he was a proxy that entitled him to information about the person in charge of a matter.
Thank you, Commissioner. According to me, sometimes when maybe I took it like this. This is a woman. Maybe sometimes when she goes to the police station, they are taking advantage of her, that they won't listen to her because she's a woman. And then she engages her boss. Now is Mr. Madlanga. And then Mr. Madlanga engages me. This is how I took it. That is the reason I'm saying a proxy. Maybe she was checking on behalf, as she alleges to me that time.
And you, as a SEPS officer, you didn't think to engage this detective to find out what's happening with the matter, because I would have thought that's what you would do, to find out for Mr. Madlanga what's happening with the matter, instead of giving him the details of an investigating officer.
At that time, Commissioner, I did not think of that.
Thank you. Thank you, Mr. Chaskasan.
Sorry, Ms. Chaskasan, unless you're going to deal with this at some point later, I need to know what this is. I don't know what this is. I see the information on the document, but I need to know what this is before we leave it. So maybe I should just ask the question. Witness F, what we are looking at on page 11, does that come from a SAPS IT system, and what is it exactly?
It's a case number, Commissioner.
No, Witness F, it can be a case number. Some of the information on the document is a case number, but the entire screenshot appears to be information from an IT system. Can you just confirm for me that this is an internal SAPS IT system that stores information about the progress of a case?
That's correct. I confirm that, Commissioner.
And would please continue.
Okay, it's a screen that shows when was the matter open and who was it located to, who is the investigating officer.
And
Commissioners,
Witness F, just bear with me. Sorry, I can't see your face, so I don't know when you are done with an answer or not. Would an ordinary citizen have access to this SAPS system?
No, Commissioner.
So only you as a policeman or your colleague would have had access to this system?
That's correct, Commissioner.
Witness F, before we leave the Impala topic, can we go to page 307?
What page number?
307 of the exhibit bundle. Do you have it?
Yes, I have it.
If you go to 1505.33, you will see that you sent a message to General Sabia at 1505.33. And before we listen to that message, can you go to 194, which is it's a set of chats from a different number of General Sabia. And at 194, also at 1505.33, we see a message sent to General Sabia. It's going to be a voice note. In fact, it's going to be the same voice note. Can I ask that we play that voice note?
Ali, can you send me a pin drop to where the box, to where the impalas must go, please, sir? If you can just send me a pin drop where it must go to.
So at 1505 on the 6th of August 2025, you sent that voice note from Rudy, farm manager, to General Sabia again. That was, gosh, almost 18 months later. And you sent it to him on both of his phones. Is that correct?
That's correct, Commissioners.
Can you explain why?
You are saying now I've sent this voice note 18 months later.
Well, to be exact, 14 and a half months later, 15 months later.
On that one, I can't remember on how or why did I send it 18 months later, but I do confirm that I did send it immediately after Mr. Mabandla forwarded to me.
Well, I had a theory as to why you might have wanted to send it to him more than a year after the event, and I'm going to put it to you. And you must feel free to answer it as you see fit. It occurred to me that by August 2025, General Sabia might have thought that it was convenient for him to try to make you a fall guy for some of the things that you had done for him previously, and that you were sending him this audio just to remind him that if you fell, he fell too. What's your comment on that?
I can't comment on that, Commissioners.
But you can't offer any reason why you would have sent this voice note in two separate messages to two different numbers of General Sabia in August 2025 when it was originally sent in March 2024.
To be honest with you, I can't remember why did I send him, but I tend to differ on your version where you say you are bringing to me that maybe General Sabia was blackmailing me on saying something else. Then as a result, I've sent that note saying, if you fall, I fall. By the time that thing was sent to me, I did not know what was it for. I did not expect it. They sent it to me by Mr. Mabandla. I sent it to General Sabia.
But presumably by August 2025, you would have realized that the fact that Mr. Mabandla had arranged for the delivery of some impalas to General Sabia's private home was not going to be well received by the public. Or by internal audit people at SAPS.
I can't comment on that, Commissioners, because I don't know.
Well, let's move on then. Can we now go to page 701? And we're now in chats between yourself and the late Deputy President, Mr. Didi Mabuza. And on page 701, on the 15th of November 2024, at 11:33, the late Deputy President forwards you an image of a weapon. Can we just, the weapon itself is to be seen in the annexure bundle at page 231. Maybe if we can just display it.
Are you ready to display the correct object?
We have got the correct object.
Oh, okay.
So that is the image that was sent to you by the late Deputy President. He followed that up with what appear to be videos demonstrating the use of this weapon. One at, well, both sent to you at 11:33:37 on the same day, like a second later after the image. Can we show those videos?
do we address them for further to get more information? And that has been happening, the process.
No.
This was for the internal processes.
Okay. Let's take out the review of the IPID report, because we know you did not do that. And we know the MMC, you drafted a letter where the MMC, in fact, forget the letter, you say the MMC said to you that the report must be implemented, right? So we are at a point where there's supposed to be disciplinary action, because that is what is directed should happen. And the MMC has said that must happen. You must implement that report. So what I'm checking with you is A2. In terms of A2, you would have been the one that looks at the allegations for disciplinary charges. So someone would have had to prepare a charge sheet, because this is now in place by the time you get to the IPID report.
Chair, this process laid out here is for all internal matters. IPID matter, being an external matter with a directive and recommendation and so on, would go and MMC says implement, it will then go to the functionaries, being the head of department and the HR department, to continue with that. We looked at as to say that what are the legal ramifications or concerns that we could have, and then, but it's unrelated to this document.
So you're saying Chief Mapieye would have been entitled with Mr. Ngwiza to carry on and get whatever necessary approvals from Mr. Kasheka, and you would not be reviewing the evidentiary material?
Not for the external part. We looked at the review of not even a review, to look at what are the challenges that we could have, but that's from a different compliance perspective. It doesn't impact upon that issue or the process of Chief Mapieye.
So you would not have become involved in the disciplinary action, that's what you're saying?
No.
This was not going to apply to the IPID's directive?
It would not, yes.
Okay, thank you. Thanks, Ms. Nair.
Thank you, Commissioner Baloy. Can we then go to page 30 of Mr. Ngwiza's statement, which deals with the second anonymous email? And paragraph 98 of his statement.
Yes, thank you, I have it.
He then says, on 2 September 2023, a further email was received from Kliki. This email was longer than the first one and went into some detail implicating of Dr. Mashazi in shielding Brigadier Mkwanazi from his disciplinary proceedings. Kliki even mentioned that my powers to do my work had been restricted in order to protect Brigadier Mkwanazi, and he then attaches it. He then says, on the 7th of September 2023, so 5 days later, I was served with a pre-suspension letter and suspended soon thereafter. What was your involvement in his pre-suspension in light of the new directive that had been issued on the 22nd of August 2023?
Okay, on his pre-suspension letter, there was a complaint that came through from MEXU. That was a criminal complaint lodged by MEXU to the police. It was being investigated by Detective Sergeant Madubanye.
You say it was a complaint from?
From MEXU. MEXU is it's a union, a minority union in the city of Ekurhuleni, where they raised a criminal complaint on fraud in terms of his qualifications. The police officer was investigating the matter. He came and saw the HOD HR. I was called into that meeting because when it comes to police officers and dealing with them, I come through to see what is actually needed. There was a subpoena issued and we proceeded there. Then that pre-suspension was as a result of that. I didn't involve myself in that pre-suspension letter that would have been created by the HOD HR.
But would there have been a decision prior to the issuing of the suspension letter that the allegations must be investigated? There would have been a request for these allegations to be investigated that resulted in the pre-suspension, which is now within your domain because the request must come to you.
There was already a police investigation out. There was a criminal case that was opened. those were already being investigated by the police officer. In the course of that, the HOD then requested for verification.
Let us adjourn, will indicate when we'll come back. Sorry for stopping you mid sentence.
Good afternoon, we're back. Good afternoon, we're back. We're just about to start. Kindly put off your cell phones. Thank you.
Mr. Behari, I hope you still remember where you were, or do you want to be prompted by a question?
Yeah, please. I think, I hope Commissioner Baloyi is feeling better. Please.
Thank you, Chair. We were dealing with your involvement in the events leading up to the pre-suspension notice to Mr. Ngqiza. We're talking about a police investigation. I'm not
Yes,
sure what the relevance of that was here.
So the matter of reported by Mexu to SAPS. SAPS were busy with the police investigation. In the course of that investigation, they subpoenaed the HOD for documents. So when the HOD was subpoenaed, I actually wanted to know what is she entitled to do, because we have certain, looking at other legislation, POPIA and so on. And I said to her that POPIA would not apply because of the subpoena, so let's give them the information that they require. So we were in that meeting with Madubanya. So thereafter, triggered from that, HOD wrote to him to say, please give us your qualifications, or what information. Then there was a response. As I don't have that full information with me, because I didn't go beyond that in terms of the entire process from there on.
Okay, so there was no request for investigation in terms of the directive that came to you?
Well, the request for investigation wouldn't come to me. As I mentioned, the informal process or the communication because HOD and I. So I would not, there was already an investigation underway by a criminal complaint from Mexu on that matter. What would have come to me, an HOD would have been taking the one because she's then acted on that and got letters. Remember, the HOD is ultimate authority in terms of that. So she acted on that and wrote to Ngqiza to get all the information. That is when the process took its course.
Okay, thank you.
If you don't mind, Mr. Behari, just increase your volume. I think your sound has dropped a little bit, so we can barely hear you this side.
Yeah, I think it's been covered by the files here.
That's fine.
Perhaps please pull the mics closer to you.
Mr. Behari, am I correct that sometime in 2024, around March, your role changed from being head of legal to now being head of risk and legal?
Yes, Chair.
Yes, I'm not asking.
I'll say yes, but there's still some issues being addressed in that matter.
And your responsibility became to advise Ekurhuleni not just on legal matters, but also on risk. So things like legal risk and reputational risk, that was now your responsibility.
Yes.
Yes. Now, from September, let's say November, because you said the IPID report was only sent to Ekurhuleni around October, November, but it was signed in September. From November 2023 until December 2025, when you were suspended, did Ekurhuleni take any action against Julius Mkhwanazi?
Not that I'm aware. I think there was action taken.
He was suspended in December after
Yes.
testimony in this commission.
Yes, he was suspended in December 2025, but he was suspended as a result of the action being taken by the city, arising out of questions posed by the Premier.
Yes.
So that is the process that unfolded through the Chief Audit Executive Office. They went through the report to Council, and that is the process. I was not part of that.
Let me put the question another way. From November 2023 until you were suspended in December 2025, did you ever advise the city of Ekurhuleni to take disciplinary action against Julius Mkhwanazi?
No, I did not, because Chair, in terms of the risk function, and the risk function speaks overall. It speaks about overall for the organization-wide risk. Those matters were being addressed at different departments at different junctures. So overall risk from that part, from when I was dealing with that from 2024, I would look at the risk matrix. What are the risk reports that have to be done? Where are the different issues of risk? So in terms of then, there was processes, one that stalled, processes with the...
Ms. Bear, please don't take me to processes. My question was, did you? And your answer is no, you did not.
No, I did not, Chair.
Yes,
as I said, it was not an aspect focusing only on the one issue. The risk function focuses on a whole lot of issues.
That is
and there are templates for that. Thank you, Chair.
That is fine. Yes. I've just handed you a document, and it is a transcript, yes, of the evidence of Dr. Mashazi on the 1st of December 2025.
Yes, Chair.
I had engaged her on the promotion of Julius Mkhwanazi. You will recall that until December 2023, he was a brigadier.
Yes.
And he was responsible for corporate services, one of the divisions there. And then from December, he was promoted to Deputy Chief of Police. Remember that?
Yes.
Yes. And the engagement between myself and Dr. Mashazi was, how can Ekurhuleni, in the face of the investigation by Erasmus and the investigation by IPID, reward Julius Mkhwanazi with a promotion? And she told this commission that Mkhwanazi had been cleared and there was no investigation against him and there was no finding of wrongdoing against him, and for that reason, there was no reason why Ekurhuleni should not have promoted him. So if you go to page 105 of 268, you'll see it's numbered at the bottom of the page.
That's correct, Chair.
Are you there?
Yes.
From paragraph 10 of that page where it says audio clip played back. Do you see that?
I see that, Chair.
Just take a moment to read that entire section.
Aloud or...
It's fine, you can read it loud.
The IPID report for us was very big, and I was unable to discipline anyone. We had to take that IPID report to our investigation. We appointed an independent investigator through the internal audit, and the report was out. We will share the report with you so that you can start disciplining people. I'm not sure. So from that report, the acting chief of police has done nothing wrong. He is cleared. So IPID, they say, can go ahead if they want to arrest him, but if they think he is wrong, because they are police officers, but from our side, in terms of the DC and investigation, there is nothing wrong that the acting chief of police has done. He has been cleared by our report, and for that, as long as there is nothing that they are doing from their side, if they believe that he is wrong, then there is nothing I can do as an accounting officer. He reports to me, even as the chief of police, who is on the suspension, he reports to me. If there is any wrongdoing on it from his side, I must do my own investigation. And I must also subject that person to a DC. I cannot subject my officers to a DC based on a report that I myself do not understand, because I had to take it to legal, and legal analyze the report and refer the report to internal audit.
Yes. So you see, she uses the word cleared twice in that clip, and she says Mkhwanazi was cleared. Do you agree that Mkhwanazi was cleared?
Mkhwanazi was not cleared by us as
Who cleared him?
If I'm looking at this, I'm not sure when or the date of that clip, Chair, but she talks to a report of internal audit. The only report of internal audit that I'm aware of was done as a result of the BXBX emails, where there was to investigate something else. So in no way do I believe that that report specifically cleared Julius Mkhwanazi or anybody else. What it did say was the process, there seemed to be, they couldn't find who drafted the documents. They did suggest that Julius must send, Mkhwanazi must send through a complaint to the information regulator, and they also commented on the fruitless and wasteful expenditure and not following of the process. But
So she was incorrect when she said there's a report that cleared Julius Mkhwanazi.
she would have been incorrect because there were findings, and that is very clear. That the audit report doesn't say we clear in that specific terms Julius Mkhwanazi.
And on 106, towards the bottom, just before the sentence that starts with "thank you," now she's referring to the IPID report, and she says, I cannot subject my officers to a DC based on a report that I myself do not understand because I had to take it to legal, and legal analyze the report. That was you.
Is she talking to the report of IPID, or she's talking to the forensic report?
No, she's talking to the IPID report. She's already said the forensic report cleared him. So she's referring to the IPID report.
So I never cleared, no one cleared out the documents that we've been dealing with in terms of the letter to IPID, but no one gave any instructions.
Ms. Berry, why do you not answer the question? I say that is you. When she says, I took the report to legal and legal analyzed the report, and I've already told you she's referring to an IPID report. Now I'm saying legal is you.
It's correct.
Yes. And she said she couldn't understand this report. That's why she could not act on it. But you in fact, in your response to this report, said it is vague, it does not support the charges against Mkhwanazi, and you criticized IPID. That's all you did.
Yes, Chair, it was part of the discussion in the letter we had framed or prepared. So all of the issues that we raised there was discussed with her, and that is hence the vagueness came in for us to clarify certain aspects with IPID. But it was not about clearing Mkhwanazi in any respect. There is nowhere we told him he's cleared. We're dealing with the IPID report, and as per the letter and the evidence now, that is what we discussed with her.
But then, as part of your duties at head of risk and legal, why did you not say to the city manager, we have an obligation to charge Mkhwanazi because that's the directive of IPID?
But the process of charging was already processed in terms of the directive of IPID. The letter that we looked at was to deal with exactly what are the fraud and corruption aspects.
No, I don't understand you. I'm asking you a simple question. Why did you not advise the city manager that IPID has directed that Mkhwanazi should be charged?
But
therefore, you have an obligation to charge him.
Sure, but it was a process already underway. It's accepted
before
as
you
that because
answer,
of the IPID report.
Maybe before you answer, Mr. Behari, in that same document, if you would look at page 93, in that same document, look at page 93, and
Yes,
then
Chair.
from line 7, she
Yes.
says, I refer the document to HOD Legal, who later informed me that the document is incomplete, and he has advised chief or whatever that they cannot take action on this document. Rather, let them do the internal investigation. So take that into account in your answer.
Is this related now to, I don't know if she's confusing the issue of the internal report, because on respect to the IPID report.
The discussion with Commissioner Kumalo is about the IPID report.
The IPID report.
Yes.
Yes. So what she says here is, you said on line 7.
Mr. Behari, you can see she's referring to the IPID report because in line 3, that's what it says. Even when you look at the IPID report, I do not know, I have it somewhere, where they write to him to implement or to discipline Julius. So from my point, I did something as an accounting officer by referring it, because it is a legal document. I referred the document to HOD Legal, that is you, who later informed me that the document is incomplete, and he has advised chief or whatever that they cannot take action on this document. I mean, that is clear advice to the city manager. The city can take action on this document, rather let them do the internal investigation.
Chair, I did not give such an advice to city manager because I never engaged with chief of police on this. Hence I asked if it was the previous one or not. That's the only other one I engaged with chief report was the internal affairs. I didn't engage with chief of police on this matter. So
No,
hence I'm saying...
We're talking about the city manager. Mr. Behari, please stop doing that. We're talking about the city manager.
She says you informed her that the document is incomplete and you advised chief or somebody, she doesn't know, that the city cannot take action on this document, which is the IPID report. Rather, they should do an internal investigation.
Chair, as I'm saying, Chair, that is not my advice to the city manager. The engagement with the city manager was that we are addressing certain vague issues in the report as per the letters that we went out. There was, and when she said he has advised chief or whatever, I didn't advise anybody for another internal investigation. I just spoke to the city manager about what were the concerns raised as per our engagements internally. And those are the only issues. I never gave city manager any advice to the extent that we said there must be another internal investigation.
So she was not truthful in her evidence?
If that is the case, she would have been mistaken or not truthful, but
okay.
not according to what I gave her.
Okay, and then did you advise that an internal investigation be done?
I did not, Chair, because there was already an IPID investigation. I did not, for another internal investigation now, because IPID investigation was already done.
Did you tell the city manager what is contained in page, remember that document which is a draft report to IPID? Is that what you said to her about the IPID report?
Page 21 of our letter.
I think it's 324. We don't have to go there. You know the document I'm talking about. The draft report to IPID or the draft response to IPID.
Yes.
What is contained in that document? Your attitude to the IPID report.
I discussed the content of that letter. So
is that what you told the city manager?
It would have included the entire document.
That the charges are not sustainable?
We believe the charges are not sustainable. Yes, correct.
So then how can you expect a city manager to proceed to charge Julius Mkhwanazi if you yourself told her that the charges are not sustainable?
Because of the process, we're still embarking to clarify it, but I did tell her that, yes.
Yeah, but if the charges are not sustainable, you cannot charge Julius Mkhwanazi.
But I explained to her what the process is. So at that stage, it is not sustainable, but we are engaging with the IPID to get clarity on aspects.
But you never engaged with IPID. You said so yourself that the letter never went out and you never followed up to ensure that it goes out.
Yes.
So in fact, you blocked the process because you didn't engage with IPID. You told city manager that you are engaging with IPID. That's how the process will go forward. And then you never engaged with IPID, which means you stopped any chance of Mkhwanazi being disciplined.
Chair, I never engaged with IPID because we were in the process of taking the letters to IPID to clarify what are we going to address. So I never engaged with IPID. I never blocked any process.
Advocate Behari, we are now looking backwards. We're not looking forward. We are 2 years later. We're looking back. You did not engage with IPID, which means it is you. You said to the city manager, the process will be, I will engage with IPID. But you did not do that. So the process stopped because you did not do what you told the city manager you were going to do.
Chair, what I said to the city manager was, in terms of the content of our letter, which was speaking on fraud and corruption, it was not talking about stopping the disciplinary process, which was addressed to Chief Mapieye. The issues that I raised with city manager on the fraud of corruption was we were in the process of dealing with the issues, and I said to her, this is what the content of our letter is.
I repeat myself, how can they charge Mkhwanazi when you have said to them the charges are not sustainable?
Chair, the issues we raised in terms of that, if they want to charge them in terms of what IPID says, it was a directive from IPID to that. Of course, later on we said it's a recommendation and we had our discussion on that. But I said to the city manager that we are engaging to clarify these issues. This is why it is vague at this stage. It's not about stopping any issues of proceeding to charge Mkhwanazi.
Thank you. I'm going to leave it there.
If you, head of legal, say to the city manager, there is no merit, these allegations, because the charge, the formulation of the charge is based on facts. There are certain facts. In your long letter, you have given a response. You say to IPID, this letter that never goes out. You say to IPID, Mkhwanazi did nothing wrong. That's really what you've done. You say Mzolo gave him tasks to do, right? And then Mkhwanazi is telling you that when he put forward the MOU and he put the donation letter forward. It was all on, accepted the donation. It was all in execution of his tasks. That's one. Two, you say he didn't register vehicles. Steyn registered to those vehicles. So Mkhwanazi has nothing to do with that. It's always been the practice to receive donations. Steyn explains that. So Mkhwanazi did nothing wrong. So Mkhwanazi sent the MOU to the chief of police, and the chief of police, the fault of the chief of police that it was not completed and signed. So in that long letter, you basically say Mkhwanazi did nothing wrong. You answer to the facts. He did nothing wrong. Now, how would you, and that's what you tell the city manager. That response is given to the city manager. That's what you tell her. How could she, and Chief Mapia, when he becomes aware of this, but forget him for the purpose of what I'm putting to you, how could the city manager then take disciplinary steps against Mkhwanazi if you, head of legal, have given responses why what IPD is saying is unsustainable? Because remember, IPD is saying he's guilty, he's committed to this conduct. You say he didn't. Look at the authorization that he had when he was acting. Look at Steyn, what Steyn says. Look at the practice. Look at what the chief of police failed to do. That's that's an answer from you. On what basis would the city manager then proceed to charge him?
Chair, the issues of which I've raised in the letter was not about IPID or to finding that Julius Mkhwanazi did not do anything. It was about consideration of, in the IPID report, consideration of the affidavit of Julius Mkhwanazi, where he said he was given this authority. If you had gone there and then done an extended investigation and found that there was no such authority, it was concretized our case, Chair. So it's not about saying that we're finding that Julius Mkhwanazi did not do anything. He raised in his affidavit to say, I was given these positions, I was dealing with these MOUs, I was dealing with these issues. And the issue to IPID was then, but have you considered the substance of what Mkhwanazi was doing?
You don't just say, have you considered? You actually say he did nothing wrong. And I'll read you a paragraph randomly. In that letter, at paragraph 6, you say, at the time of the vehicle registration, the benefit of in brackets, you say getting more vehicles, would have accrued to the city had the deal been approved. The cost incurred in the registration was a step forward, was a step towards obtaining the benefit on behalf of the city. It would be challenging to argue that the registration costs constitute prejudice to the city. The registration costs should not be viewed in isolation, but as part of the entire process of acquiring the benefit on behalf of the city. So your theme throughout is no, but this was to the benefit of the city. You say that, no. And it doesn't matter whether it's criminal or disciplinary process. You, head of legal, are saying this whole transaction was for the benefit of the city. He did nothing wrong.
Chair.
And you tell that to the city manager. How can the city manager charge him for that? For registering these vehicles, for incurring the cost of registering these vehicles?
Chair, as if the donation had completed legally, the intention was very clear to have benefited the city. That is what we were speaking to. It wasn't about him.
It wasn't to benefit the city. The vehicles were never going to be transferred to the city. We've looked at the MOU. Don't reprise what that MOU says. We've looked at it. We've looked at all those documents. We've had Brigadier Mkhwanazi here. Those vehicles were never intended to come to the city. They remained with Mr. Matlala's company because that was the intention. They were never intended. So they were going to be driven, and it happened that way. They continued to be used by Mr. Matlala's people, not your city. So there's no benefit that came out of it to the city. The MOU contains nothing that says these will come to the city. You say there's nothing wrong with all of that. And you say that to the city manager. So what I'm putting to you is when the city manager says, I was advised by head of legal that there's no merit or the complaints are unsustainable, and so I could not discipline, forget her motives, and I couldn't discipline, there's nothing wrong in her saying that, because her head of legal, has expressed the views that he has expressed in this letter.
Yes.
Yes.
So I have expressed that view, Chair, and I said to, and then the document details why. Now, in respect of, you say it was never intended to, at the stage when we considered that report, there was no linkage to say that it was never intended for. The only issue we picked up even from the initiation was it was a donation to the city. A donation then will speak to a document or vehicles or whatever the donation item would be, being transferred to and being used by the city. So if there was an intention never to transfer the vehicles or never to bring it back to allow to be used by elsewhere, I don't see that anywhere in that Chair, specifically mentioned. But if it is a donation, understanding that part from a donation, that would have covered that the city would be the ones benefiting.
You see, we're having this discussion with you. We've had the benefit of the evidence of Brigadier Mkhwanazi even, and the documents that are involved in this. And from that evidence, from that evidence, we know that it was never the intention to deliver the vehicles to the city. We know that. They were always going to remain with Mr. Madlanga.
Okay.
That is the evidence,
yes.
right? You say that was to the benefit of the city, because that's what you're saying. In fact, you say, on the contrary, again, I pick another random paragraph. You say it is difficult to see how CAT benefited from the registration of the vehicles as they transferred ownership of their vehicles to the city. Well, he benefited because he was driving around in unmarked vehicles that when they are checked on the system, they are known to be EMPD vehicles. So they opened doors for him to go wherever he wanted under the name of the EMPD. And then you say, on the contrary, CAT sustained a loss of assets while the vehicles were registered in the name of the city. There's no basis for you to say that. He always had control of these vehicles. The city is the one that stood to benefit, particularly considering that EMPD had a shortage of vehicles and there seemed to be no effort from the chief of police and senior management to address this. The purpose of the vehicle registration was to increase the number of vehicles to be used by the EMPD. There's no facts for you to say that. There was no facts whatsoever, not from the documents, not from anything that Brigadier Mkhwanazi said, because in that warning statement that you pulled out, the warning statement, it does say that they returned, they were never delivered to the city. Yeah. Right? So I don't know what facts you were relying on when you say they would have increased the vehicles to be used by the EMPD, because they never came to the EMPD.
In that,
but don't lose sight of what this part of the discussion is. Yeah. This part of the discussion that Commissioner Khumalo started with you is that you advised the city manager. You spoke to the city manager. She saw this long letter, but you also had a discussion with her. So when she says, my head of legal says that the complaints or the allegations against Brigadier Mkhwanazi are not sustainable, she's right. That's what you've said.
Chair,
she's right. You said that to her.
Chair, on two aspects. The first one is, at the time we considered the document, Mkhwanazi's evidence, of course, was not there. We considered the document purely looking at the IPOD report, and we crafted our response in that regard. So yes.
But you also had his statement, warning statement, because if you didn't have the warning statement, then it raises another question. When you say to IPID you didn't consider Mkhwanazi's statement, what would you have been referring to, right? So you must have had sight. Otherwise, you're commenting on incomplete information.
We did have sight, and hence that is the document we refer to here. When Commissioner Khumalo mentioned the other document from, I think, this is why we had the insight. We asked him, did you consider the impact of that? Because in the documents that was contained there, it's referred to functions continuing to deal with the issue of functions given to him by Mzolo, which included the drafting of the MOUs. and for looking at then the donations issue. So that in that statement of his linked to the IPOD report, it spoke about donations. So when you say it was not transferred, the vehicle was transferred into the name of City of
They were
Ekurhuleni.
never given to the city. They were never available to EMPD to use. And the MOU does not say they were going to be delivered to the city. That's the simple point I'm making, and that's a fact. The
Chair.
MOU, if you read that MOU, and I'm hoping that when you expressed these views here, you had considered all the documents, and that would include the MOU. And if you did read that MOU does not say they will be given to the city, right? It says they will remain with CAT VIP, those vehicles.
Yes, Chair, the MOU stated that. But in terms of and this is why we asked with regards to the IPOD report. If you look at paragraph 11 of his document, CAT VIP would donate 4 vehicles which would be registered under the City of Ekurhuleni to be utilized by EMPD officers. Okay. So when he came here and then said no, it was used by them, at that stage when we crafted this document, there was no such thing before us. And
I accept that. I accept that. We can move.
Thank you. And then come back then to Commissioner Khumalo. So yes. The basis of us informing was based on the consideration of that, where we come to the letter that was drafted, and I would have informed City Manager based on this. There are issues that are vague, which we will be addressing.
So,
and these issues that are vague, I don't see what is vague in the IPIT letter, and you and I had that discussion yesterday. When you say they are vague, there are issues that are vague, and you tell the city manager, and she relies on that not to institute disciplinary proceedings, because that's her interest, right? Yeah. Her interest is not in the criminal case. Her interest is that disciplinary action be taken. What the DPP does is a different process altogether. It's an IPIT DPP process. Your organization's role in this, and that's why I don't understand why you wrote this letter, but the role of your organization arising from the IPID investigation and report to you is the directive to institute disciplinary proceedings. It's the one thing you don't address because you say it's with MAPIA, but you go and comment to the city manager to say these charges are not sustainable.
Yeah. Chair, we crafted that on the basis, and said even from yesterday, the functions that were given to us is to look at the fraud and corruption part. We focused on that issue. There was no link to the HR processes in any way in the document. We focused on the fraud and corruption for our processes going forward with impact and so on. In that, because you're dealing with a holistic document, we analyzed the report of IPID, and those were the issues we found would be vague in terms of what we still needed to address.
Was it your initiative to analyze the report, to analyze the fraud and corruption part of this report? Did you, without prompting, choose to do that?
Chair, City Manager would give us can we look at the criminal aspects of this issue?
No, she did not do that because in your statement you don't say that. In your statement you tell us what she said to you. So she didn't say to you.
In her statement, or in my statement, sir?
In your statement, I'll read, I think Ms. Ngube, if you could refer to that paragraph. You do tell us what she said to you, and it has nothing to do with what you end up doing. I'll find it. We looked at it yesterday. I put it to you yesterday. Yes, here. If you look at your paragraph 181 of your statement, you say the city manager requested that the Legal Services Department prepare a draft response acknowledging receipt of the report and addressing certain technical issues that IP did not clarified, including The status of matters referred to the Director of Public Prosecutions for decision. We know your letter doesn't do that. The scope and confidentiality of the report. We know your letter doesn't do that. The distinction between preliminary investigative observations and findings capable of immediate implementation. Your letter doesn't do that. So you do tell us what the instruction from the city manager was. And
Yes, Chair.
this suggests that you went and did your own investigation of the charges.
It's not the investigation, Chair. It's an assessment of what is contained in that report.
Yeah, that was your initiative.
So-
it
so
didn't
in-
come from the city manager.
Yes, so we briefed the city manager on that and said, so before we move forward, we had to clarify all of the issues. So that is what the extent of it was.
Before you move forward with doing what?
With-
Because remember the letter from IPID is very specific. It asks only of one thing. Ask one thing of you, which when I say you, I mean the city. It's institute disciplinary proceedings. So when you say we need to clarify before we go forward, what is the going forward to?
The going forward to deal with the other issues she's raised, Chair, which is in terms of, okay, the classification watch, it was already there, but at least on the evidence that we would be requiring to move forward in terms of first clarifying the fraud and corruption, that seems to be instrumental as well to the criminal aspects we were looking at, and for our own interest in terms of the impact and counsel. It would have also had an overlay into the disciplinary processes because of the evidence that was required. So that is what the basis
So to
was to
say that
clarify.
last part about the disciplinary process, you say
It would have had a leg in terms of the evidence being tested. As we got a response from that aspect, it would have had a leg on the disciplinary as well.
So if you got the answers that you were looking for, you are saying that would also feed into the disciplinary process.
It would feed into disciplinary.
Okay. Thank you.
Advocate Behar.
Let us adjourn and resume at 2:10.
1, 2. I don't mean to break up the party there, but we're about to start. Please switch off your cell phones. We are ready to start. Thank you.
Yes, Ms. Sigels-Nube.
Thank you, Chair. May I proceed, Chair? Thank you.
Yes, please.
Mr. Behari, there's just two loose ends that I want to tie up with you. The one relates to your repeated refrain about how the IPID report was addressed to Chief Mapiyeye, and he was the one that had to go ahead with the disciplinary proceedings, so that there was the directive that he must initiate those proceedings. Now, I just want to discuss that with you within the context of when that directive comes. You know, it comes after the 22 August 2023 change of delegation. And importantly, it also comes at a time when Mr. Ngiza is on suspension, correct?
Yes, I think so.
And so I just want to understand from you, how was Chief Mapiyeye supposed to initiate those disciplinary proceedings? Because we know by now that the first disciplinary proceedings had been withdrawn, the investigation had been withdrawn, which effectively means the charges had been withdrawn by June 2023. So how was he going to get these charges or initiate these disciplinary proceedings in light of that new directive, the delegation matrix, on your version? How was he going to do that?
Chair, he would have to engage with the HOD, HR. So remember, all the disciplinaries in the city, even after that letter, and the system of delegations, the HODs were still, HR was still ultimately responsible for disciplinary proceedings. So the HOD, being Chief of Police, will engage with that HOD.
And you are, of course, aware of the allegation by Ms. Ngiza and Mr. Chief Mapiyeye that Ms. Gasheka was part of the clique that was trying to protect Brigadier Mkwanazi.
Yeah, I think I couldn't avoid that allegation even from the outset. It is there. The clique was mentioned.
Yes. So can you appreciate the difficulty that he would have been confronted with in not initiating those proceedings without, at the very least, even if you had to apply this new delegation matrix, if it is a directive from IPID that says institute proceedings, the disciplinary proceedings, would he still have to come in terms of that new matrix to request for an investigation to be done?
Chair, if it's linked to the maybe not having any confidence in HOD Linda because of the being identified in a clique, there are other processes available to him. Remember, it comes from the MMC Masuku who received the documents. He could have went to MMC and said, I don't trust the city manager, I don't trust HOD HR, and I don't trust HOD legal. So what is the further option? So MMC could have taken down his complaint and proceeded. But you cannot say that because I believe you're in a clique, we're not going to take the process forward. There's options available if you have that problem.
Okay, and then insofar as the 22 August 2023 matrix, delegation matrix concern, you mentioned the meeting that happens on the 17th of August when I asked you what preceded the 22 August matter or delegation matrix. Chief Mapiyeye says that there's something that happens even before the 17 August meeting. If I could just ask you to briefly go to his statement on page 28. At paragraph 104. Page 28, paragraph 104. Are you there?
Yes, I'm there, Chair.
So he says at 104, on 15 August 2023, I delivered to the city manager the letter of intent to institute proceedings regarding the precious stone theft allegedly committed by members of the EMPD who were reporting directly to Brigadier Mkwanazi. When I delivered it to her, she challenged me on the fact that the letter does not make any reference to Brigadier Mkwanazi and neither does he appear in the attached pictures. She suggested that I was persecuting Brigadier Mkwanazi and was biased towards him and threatened to suspend me with immediate effect. She immediately corrected herself and told me that she was actually suspending me with immediate effect. On 17 August 2023, the city manager called a meeting at which she claimed the department was dysfunctional and having at the conclusion of which she stated that she had decided that I shall take special leave with immediate effect so that I can clear my head, rest and come back neutral with no bias. I was placed on 30 days leave. See that?
Yes, Chair.
All of this happens just before the 22nd of August. So we've got the 15th of August. He comes with new charges that he's got against Brigadier Mkwanazi. The 17th, that meeting happens. Then it's the anonymous email on the 20th, and the 22nd of August 2023 is the new delegation. Have you had any regard to the fact that these could also have been factors in what motivated the delegation, the new delegation matrix?
Chair, I became aware when I received the letter of demand from, I think it was the attorney's firm, on the precious stones. I'm not so aware of what happened prior to that in the discussions, but yes, I only became aware after that as regards the meeting held with the other officers. The discussions between on the special leave and so on happened between Chief of Police, City Manager, and HOD HR. I accepted it to be arising out of the complaints, which I believe were serious, in the 17th, the meeting of the 17th. So at the meeting, I think it's important that, it's on record now, so you can go through that. But there were several issues raised, and I understood then, I think it was around the next day or so, that I was called in terms of a service of a letter of leave, special leave. And I understood it to be that he had requested to be placed on leave. He could not have any days leave left, and the only option apart from unpaid leave was special leave. So that is the only aspect I dealt with it from there.
Mr. Barry, sorry, Mr. Barry, this meeting on the 17th of August, earlier when you were discussing this change in disciplinary steps, who takes what decision, you referred to a meeting where there were complaints, there were camps, and there were complaints, including against Mr. Ngiza. Is this meeting of the 17th of August?
Yeah, the 17th of August, there seemed to be a meeting between Chief of Police and City Manager, which I'm not aware of, Chair. But the meeting I'm talking about, there was a meeting 17th where the complaints were coming from EMPD.
Yes, my question is about the second, the latter.
Okay.
The meeting where everyone was present, where there were camps. I think that's how you described it. So there were camps, you described it that way. That's a meeting of the 17th of August. Yes. You were present in that meeting?
No, I was not.
All right, thank you.
Thank you, Chair. No further questions from me.
Thank you, Ms. Sigel.
Mr. Behari, very quickly, can we go to that document that I asked you to look at? It is the transcript of Dr. Mashazi's evidence, the very last page.
No, I think I understand now why you called me Mr. Mashazi yesterday, Chair. You seem to be fixated on that.
Do you see now? So, Mr. Barry, are you there?
Yes, Chair.
Because
From paragraph 9, maybe just take time and read paragraph 9 to 17.
Sorry, Chair, just to quickly the date, the page again?
The last page.
Oh, okay.
So it will be page 110 of 268.
Yes, Chair.
Are you there?
Yes, sir.
From paragraph 9, Dr.
Yes.
Mashazi, start there until where she stops, just before Advocate Sillo.
Yes, Chair.
Just read it loud, please.
Read out. The report was fully analyzed by corporate and legal. Hence, I can allow Advocate Kemi to come and talk to the report and also talk to his opinion about the report. And I indicated at the beginning of my response that if I was ill-advised or given an opinion that is not sustainable from the department, can we allow Advocate Kemi to come and speak to the report? That is all I'm asking.
Yes. So it's quite clear that she relied on your opinion.
On that report that we drafted, or
Yes.
me?
Yes.
Yes, on both aspects.
And she says if that opinion was wrong and she was ill-advised, you must come and talk to that because she relied on it.
Chair, yes. She's my accounting officer. I'm the head of legal.
Yeah.
If I discuss a report with her and if it's incorrect in terms of what she says, then of course I must talk.
So at least she has a defense. Her defense is, my head of legal said these charges are not sustainable. I relied on that.
No, correct, Chair.
Yeah. So it's for the head of legal to now come and defend his opinion.
Yes, Chair.
Yes.
That is the letter of, we were talking about the draft letter.
Yes.
All right, so.
Yeah. And
So
then
that-
finally, sorry, I may have interrupted you. You wanted to say something?
No, I'm just saying, Chair, that is what the input with Dr. Mashazi was, was based on the drafted letter from the city of, from us, from the legal department.
All right. And to be fair to you, we have a witness that's going to be giving evidence after you, and it's Mr. Shega. You are familiar with her. She was HOD for...
Yes, I am.
Yes. And she has prepared a statement for the commission. We've had the opportunity to read it. You have not had the opportunity to read it. But there are 3 paragraphs in her statement that concern you. And it's only fair that we let you have regard to them and simply confirm to us whether what she says is accurate or not. I'm actually thinking of giving you the 3 paragraphs for you to look at, and then maybe...
Commissioner Kumalo, I did give it to the
Oh,
witness.
you have it there. Thank
Yes,
you,
he does have it.
Advocate Seagulls. Paragraph 27.3 and 27.4 on page 9 of Mr. Shega's statement. Please just read those 2 paragraphs and confirm whether what she says is accurate.
27.3, around the month of May 2023, the accounting officer called Chief Mapiyeye, Kolani Niza, HOD, Kemi Bihari, and myself into a meeting. She wanted answers as to why the disciplinary hearing of erstwhile Brigadier Makunazi has not commenced. Mr. Niza provided an explanation, including that the processes were at an advanced stage. The investigation has been concluded. The appointment of the presiding officer and prosecutor is underway, and the charges are to be drafted soon accordingly. So on that paragraph, Chair, I do recall there was concerns around the delays in the process. I can't, specifically recall that exact meeting on that day, but I do recall there were discussions in the delay of the processes.
You can't dispute what she says.
I can't dispute it, Chair.
Thank you. Next paragraph.
27.4, although I cannot recall all the facts at this point, Dr. Mashazi then explained that the disciplinary code agreement talks to 3 months to conclude a disciplinary proceeding and that it has expired. There is no need to extend it. Erstwhile Brigadier Mkonazi was to come to work. Instead, we were to account for why the investigation was not concluded, if not.
Do you dispute what is recorded in 27.4?
In terms of the meeting, yes. I'm not disputing it, Chair. As I said, I cannot recall to the extent of it, but there was concerns about the delays in the process up to then.
So I take it you're not disputing what is
No,
recorded there. Page 12, paragraph 37.
Must I read it as well, Chair? In August 2023, the accounting officer raised the issues relating to how the labor relations cases are handled, especially EMPD cases, including the case of Brigadier Mkonazi, as it was now raised via an anonymous persons or emails. When we were called to account, HR could not fully account for it, especially Mr. Gneza. The accounting officer raised more than the non-management of labor cases by Mr. Gneza and how the issue of charges was managed. In the discussion, it was suggested that HOD Kemi and me be fully involved in the issue of disciplinary process, and the instruction was very clear, hence the new procedure was developed.
Do you dispute what is recorded there?
No, it actually supplements or adds to what I've been talking about in terms of the report, Chair.
All right. Just one thing, you see there it talks about the anonymous emails, and arising from that, you appointed an audit firm, remember, to deal with the leak.
No, Chair, when the anonymous emails came through to our attention, I engaged with the city manager to say these are concerns which we need to address as information officers. She then called in, I think it was, at that stage it was the CAE Lindiwe Hlaza. And thereafter, I didn't follow the process until the appointed firm then contacted us for information as to what is required.
And then in their report, the so-called audit report, if you remember correctly, in one of the late paragraphs in their recommendations, they actually recommended that a legal opinion be obtained on the prospects of succeeding in a disciplinary process against Julius Mkhwanazi. Do you remember that? It's in paragraph 27 point something, 1.27 or something like that.
Yeah, I did look at that part where a legal opinion needed to be obtained.
Sorry, it's actually paragraph 13.9.2 of that audit report. I think you have it in front of you.
Yes, first obtain a legal opinion.
Just read it, please.
Section 13.9.2. First, obtain a legal opinion on the city's prospects of success prior to commencing or instituting disciplinary action against Mkhwanazi in light of inter alia, those aspects.
Yes. Did you obtain that legal opinion?
No, Chair.
No, yes or no. Did you obtain it?
This I don't believe will be a yes or no answer, Chair. I just want to go back to, this comes from 13.1. In the findings, in the circumstances, NISA had an obligation to first obtain a legal opinion. So it was about NISA obtaining the legal opinion, not me, Chair.
No, but it's now August. We know that in terms of the new code, NISA has no authority. There's a recommendation that Ekurhuleni should obtain a legal opinion. Only you can do that at this stage.
Chair, in terms of the processing of the forensic reports, there is a process that we take it through. Then only does it come back to us to say, okay, implement these findings or not. So at that stage,
was it implemented either by you
not
or by
me? Not by me.
And you know he was suspended, so I don't know why you're saying NISA should have done this. Because he was suspended, he couldn't do this.
Chair, if he was, as I say, Chair, there's a process for processing forensic reports. When you go to MPAC, which the internal audit department does, then MPAC comes back and say, okay, deal with these issues. I did not deal with this issue because it was not about, the finding was not against us. It was about not proceeding further, firstly, in terms of what ought to be, and hence the findings were made against NISA. He ought to have done that. It was the finding that was made against him at that stage.
I'm done, but I find it strange that NISA, who's the subject of the investigation, because he's one of the suspects, somebody suspects that he's the one who leaked the documents and he's the author of the email, and he's under investigation. Then the report must go to him to implement the very report that investigates him. I just find that very strange.
Chair, okay. I'm saying that there was a report. This is a forensic report on the findings of what transpired before. Right. The report is not for NISA to implement at this stage. It is a report of the forensic audit that goes to internal audit department. Internal audit then takes that with a report to MPAC to say this is what the situation is. These are the findings, either fruitless and wasteful expenditure, where are the irregularities that occurred, and then it goes to MPAC, and then MPAC makes a recommendation on the way forward. So at the time of the finding by the internal audit company or the forensic firm, it means that we found these issues that should have been done before we proceeded to that extent. So that is where, so at that stage, there's no indication to me to deal with that, Chair. I hear you're finding it strange, but that is the process I can describe in terms of processing internal audit reports.
Just find out who ordered this report, this investigation, what you call the forensic investigation.
Okay, so Chair, arising out of the BX emails, when it came to our attention, I went to City Manager, we discussed the issue in terms of our compliance. CM then discussed the matter with the internal audit, Chief Audit Executive, Ms. Lindiwe Hlaza. And thereafter, we know that Mr. Philip Rachwale, when he started acting, then he processed the matter with the appointment of the firm and engaged further on that.
So you didn't appoint the firm?
No, Chair.
Thank you, Chair. That's all for the witness.
Thank you very much, Mr. Behari. You are excused.
Thank you, Chair. Oops.
Chair, may you indulge us with an adjournment for us to prepare ourselves for the next witness? 10 minutes, please.
We'll come in when you indicate.
Thank you, Chair.
Let's adjourn.
Good afternoon, good afternoon, everyone. We will be needing some time to deal with one or two issues, and we will advise as soon as we are ready. Thank you. All right, it seems we are ready to resume. Cell phones, please make sure that your cell phones are off. Thank you.
Yes, Ms. Sigels-Ncube.
Thank you, Chair. Chair, the next witness is Ms. Kasheka, and there's been 2 statements filed by Ms. Kasheka.
Perhaps
Yes, they're on
before you
record.
go on, may I?
On record, yes. My apologies, Chair.
Yes. Please place yourselves on record.
Afternoon, Chair. My name is Ofensa Mokhosi from Mokhosi Care Attorneys. I'm with my counsel, Advocate Magula. Thank you, Chair.
That's a bit unusual for me. It's usually the other way around. It's counsel who usually announces themselves and then say, I'm instructed by. That's a bit odd.
Thank you, Chair. My name is Emma. Please. Thank you, Mr. Chairman. My name is Emma Magula. I'm an
Sorry, the surname Mu?
Magula, Magula.
Thank you.
Yes, Mr. Commissioner. And I'm representing Ms. Linda Louisa Kasheka in this matter. It's a brief or an instruction, Mr. Chair, by Mokhosi Attorneys.
Thank you.
Thank you, Mr. Chair.
Thank you.
Thank you.
Thank you, Chair.
Yes.
Chair, yesterday afternoon we received a supplementary statement from Ms. Kasheka's attorneys. It's 44 pages long. We have not yet had an opportunity to fully prepare on that statement in order for us to do her cross-examination. The intention was that we would start with her statement, but due to scheduling issues, we need to reschedule her evidence so that we can start and finish it all in one go. And so, given that we've had such limited time to have regard to her statement and prepare on it, we have agreed on a date by when we will resume her evidence. She is under subpoena, and we have agreed to the date 26 and 27 February, Chair.
Do you confirm, Ms. Magula?
Yes, I confirm that it is so arranged, the dates are so arranged with the evidence leader to the 26th and 27th of February 2026. Confirm.
Thank you. No, I just wanted to be sure of the spelling of your name because sometimes I've heard people say Kasheka. So I wanted to look at it written for myself. So I see that it's actually Kasheka. Good afternoon, Ms. Kasheka.
Good afternoon, Commissioners.
The hearing of your testimony is postponed to 26 and 27 February. You are directed to be in attendance on that day. And as you are aware, you are here on subpoena. And I'm sure you are aware of the consequences of your failure to be in attendance.
Thank you, Commissioner.
There may be criminal charges, there may be criminal sanctions for your failure to attend. At 9:30 on both days. Thank you. Let's adjourn and resume
at 9:30
tomorrow.
Correct, Chair.
Let's adjourn.
Thank you.